the 9:30 a.m. session.
Let us pray. Almighty God, who in your wisdom and goodness have appointed the officers of leaders and parliaments for the welfare of society and the just government of the people, we beseech you to behold with your abundant favor as your servants whom you have been pleased to call to the performance of important trust in this republic. Let your blessings descend upon us here assembled, and grant that we treat and consider all matters that shall come under our deliberation in so just and faithful a manner as to promote your honor and glory, and to advance the peace, prosperity, and welfare of our country and of those whose interests you have committed to our charge. Amen. I direct that we ring the bell for another 10 minutes.
Having not achieved the requisite number and pursuant to Standing Order number 34, the bell has been rung to allow members of Parliament to walk into the House, and so that the second session morning sitting of Wednesday, August 23rd starts. And members of Parliament are expected to deliberate on a motion brought by Kiambu Town Member of Parliament, Honorable Mashua Waithaka, where the question is expected to be put on the national policy on deworming of school-going children. Where the Article 41A of the Constitution provides that every person has a right to the highest attainable standard of health, including healthcare services. The relationship between health and education plays a significant role in school attendance rates. The negative effects of poor sanitation, such as parasite infestations, particularly among the school-going children, leads to anemia, stunted growth, and other salient problems, which in turn leads to low attendance and impact education standard. And according to research, school-based deworming is one of the most effective intervention that provides a huge range of holistic and social benefits, such as increased school attendance and healthier kids who do better in school, while already utilizing existing school structures and administering deworming treatments to school pupils. Recalling that the previous programs conducted by the Ministry of Health in partnership with non-governmental organizations have only been piloted in few selected counties in the country, that the deworming efforts have been uncoordinated and dependent on external support with no clear policy and budgetary frameworks, And now the House urges the national government through the Ministry of Health to develop a national policy on deworming school-going children as a crucial part of mainstreaming of healthcare services across the country. There is also a motion where the question is expected to be put, brought by Honorable Felix Odiwar, the Member of Parliament for Langata constituency, on the public health concerns at Langata Cemetery, where the House urges the national government through the Ministry of Health to urgently conduct an assessment of the public health risks posed by the continued use of Langata Cemetery and to institute mitigatory measures to collaborate with other stakeholders, including the Nairobi City County government, to identify a suitable alternative land for use as the cemetery. According to Article 42 of the Constitution, it provides for the right of every person to a clean and healthy environment. Article 69 of the Constitution also obligates the state to ensure sustainable utilization of the environment and natural resources, including land. Further, schedule to the Constitution assigns to the national government the function of land planning, including the general principles of land planning and coordination of the planning by counties, as well as matters of health policy. The matter has been left unaddressed and poses a significant health risk to the public. I'm deeply concerned that the situation has led to overcrowding and double allocation of burial sites, with bodies being buried in shallow graves, leading to frequent uncovering by wild animals from the nearby national park. It's also concerned that it has caused untold anguish, pain and suffering to the bereaved families and psychological torment to the neighboring community of Langata constituency. And the quorum has been achieved, and I will hand you over to the plenary. My name has been Angela Cherol. Thank you.
I think we now have quorum. We may proceed. We may proceed. Order, honorable members. Order, honorable members. We're going to begin the session. Honorable Kamket, I think you should break up your Kamkunji. Order. Let's proceed. And Didimas, Honorable Didimas Baraza.
Order number 1, administration of oath. Order number 2, communication from the chair. Order number 3, messages. Order number 4, petitions. Order number 5, papers.
Chairperson, Departmental Committee on Blue Economy, Water and Irrigation, Honorable Bowen Kangogo.
Thank you, Honorable Speaker. Madam Speaker, I beg to lay the following paper on the table of the House. Today, Wednesday, 23rd August 2023, the report of the Departmental Committee on Blue Economy, Water and Irrigation on the study visit to the Namibia on 12 to 15 June 2023. I have a second one, Madam Speaker. Madam Speaker, I also have a second one. Honorable Speaker, I beg to lay the following paper on the table of the House. Today, Wednesday, 23rd August 2023, the report of the Departmental Committee on Blue Economy, Water and Irrigation on its considerations of the Water Amendment Bill, the National Assembly Bill, number 33 of 2023. Thank you, Honorable Speaker.
Next, the Chairperson, Departmental Committee on Environment. You have a paper? Proceed, Honorable Gikaria.
Thank you, Honorable Speaker. Honorable Speaker, I beg to lay the following paper on the table of the House. Today, Wednesday, 23rd August 2023, report of the Departmental Committee on Environment, Forestry and Mining on its consideration of the Climate Change Amendment Bill, National Assembly Bill number 42 of 2023. Thank you, Honorable Speaker.
Next order. Honorable Shira, do you have a point of order?
Thank you,
Yes,
Honorable
I
Speaker.
noticed actually that you have a paper to table, yeah?
Yes.
Okay, proceed, Honorable.
Thank you very much. Honorable Speaker, I beg to lay the following paper on the table of the House today, Wednesday, 23rd August 2023, the report of the Select Committee on Members' Services and Facilities on its standing visit to the House of Commons of the United Kingdom Parliament from 16th to 13th May 2023. Thank you, Madam Speaker.
Thank you. There being not any other paper, I think we can move to the next order.
Order number 6, notices of motion. Order number 7, questions and statements.
I think Chairperson, Select Committee on Implementation.
Thank you, Madam Speaker. Statement regarding the agreement between the government of the Republic of Kenya and the government of the Italian Republic on the Luigi Broglio Malindi Space Center by me, the chairman of the Committee on Implementation. Honorable Speaker, I rise to issue a statement to the House regarding the implementation status of the agreement between the government of the Republic of Kenya and the government of the Italian Republic on the Luigi Broglio Malindi Space Center, as requested by Honorable Owen Baya, CBS MP for Kilifi North Constituency on Tuesday, 13th June 2023. Honorable Speaker, the matter seems to have taken inordinately long to respond to due to delay in response from the management of the Italian Space Center in Malindi. Nevertheless, we now have received the response and we have shared it with Honorable Owen Baya, CBS MP. Honorable Speaker, even as I table the response as received, appended to this statement, allow me to give the House a brief on the issue for the benefit of all members. Honorable Speaker, the Kenya Italy bilateral agreement on the Luigi Broguglio Malindi Space Center was ratified by this House on 15th October 2020 and came into effect on 16th December 2020, following completion of exchange of diplomatic notes on the agreement between the two governments. The implementing parties on this agreement, which guides the management of the Space Center, which is located in Malindi Space Center, are the Kenya Space Agency and the Italian Space Agency. The center sits on 3.5 hectares of land under the Ministry of Defense. Honorable Speaker, the agreement provides the framework of collaboration between Kenya and Italy on peaceful use of outer space for scientific, technological, and socio-economic development of both nations, among others. It also provides for joint management of the Luigi Broguglio Malindi Space Center. The cooperation framework is premised on 5 implementing arrangements as follows. A, support to the Kenya Space Agency. B, access to Earth observation and space science data. C, education and training. D, telemedicine. And E, establishment of a center for Earth observation. Honorable Speaker, the government of Kenya is concerned about the slow pace of implementation of the agreement, and I would like to inform the House that as a result, the Committee on Implementation has been following up on the implementation of the same. Unfortunately, Kenya is yet to see significant tangible benefits of the cooperation, and the truth be told, there is nothing much to show for it, either at the national level or even in the local community around the Space Center in Ngomeni, Malindi, Kilifi County. Honorable Speaker, the current activities at the Malindi Space Center are exclusively benefiting only the Italian Space Agency and its Western partner agencies through tracking, telemetry, and command services, and provision of space science and astronomical data to the Western scientific community. The facility is currently undertaking a number of commercial activities in support of satellite launches and provision of telemetry, tracking, and command services to a number of clients, including the French Ariane Space, European Space Agency, NASA, SpaceX, Chinese Aerospace Administration, and other international clients, with no significant share of profits accruing to the government of Kenya. 3 years into the new agreement, there is no traction on implementation of the agreement. The Italian side has made only token fulfillments on select obligations while avoiding the substantive ones. I wish to inform the House that the Committee of Implementation visited the center on the 11th of August 2023 to follow up on the status of implementation of a report that had been tabled by the Committee on Defense, Foreign Relations and Intelligence regarding this emotive matter. The agreement under Article 5 mandates the CEO of both the Space Center as part of the Joint Steering Committee. The CEO from the Italian side was not present for that particular meeting, and thus no one present from the Italian side would adequately answer the members when called upon. The Italian ambassador clarified that he had sent a reply to the questions that had been sent their way a day before the scheduled meeting. The committee agreed to meet them on a later date, and that's within the next 2 weeks we are supposed to be meeting them again. Honorable Speaker, The Ministry of Defense has equally raised its dissatisfaction over the same matter and now is seeking the intervention of this House for the push for our country to have its significant share of the benefit that derive from activities at the Malindi Space Center. Such matters include A, full disclosure and visibility into the commercial contracts entered into by the Malindi Space Center with third parties. B, establishment of Center for Earth Observation for access to crucial Earth observation data, as well as capacity building on development of applications. C, more presence of the Kenyan government personnel and visibility into the operations of the facility, including the commercial contracts. D, tangible capacity building and support for the growth of Kenya's space sector. And then E, joint project that is impactful and beneficial to Kenya. Honorable Speaker, that is a synopsis of the response, and I hereby submit the entire report as received from the Ministry of Defense and the management of the Italian Republic through the Ministry of Foreign Affairs. I thank you, Madam Speaker. I thank you, Madam Speaker. I table the report.
Thank you. Yes, Honorable Owen Bayer.
Thank you, Honorable Speaker, and I want to thank the Chairman of Implementation for the work they're doing. I raised this statement, Honorable Speaker, on the premise that the Luigi Broglio Center has been there for many years, but it has not benefited the people of Malindi, specifically the people of Ngomeni and Magarini constituencies where it is situated. Ngomeni is still a very poor place in spite of the lot of revenue that this center gets. Honorable Speaker, I want to thank the committee. For the first time, Parliament has been allowed into that center for the first time in the history of this country. And I want to applaud the chairman for that effort, and also the Ministry of Defense for pushing to ensure that we get information from this very secretive space center. But I want to urge them. I know the ambassador has been trying to get to talk to the committee to understand what they are doing. But I would like to ask you to be tough, to get to the bottom of it. Kenyans must and should benefit from this. This parliament, the 12th parliament, which I sat in here, approved the agreement, the bilateral agreement, and it came to this chamber, and we debated, and we agreed in principle that we will approve this on the premise of the many projects that were to be undertaken in that agreement. That agreement, if you read it, you see there are projects for the community, there are projects for government, there are scholarships, but I have read the note verbal from the Ministry of Foreign Affairs coming from the Ministry of Foreign Affairs in Italy. And they will tell you that they have offered so many scholarships, so many hundreds of scholarships in that letter. But I have not seen anybody from Magarini or from Malindi or from Kilifi who has benefited from those scholarships. So who are these people that are being given these scholarships that this ambassador is talking about? Honorable Speaker, I think it is time that we interrogate all agreements that come to this chamber and ensure that they have a benefit for the community. So in the 2 weeks that you have asked for, I am sure you will unearth these issues and ensure that the people of Ngomeni, the people of Magarini, benefit from this Broglio Space Center. I thank you.
Yes, Honorable Bowen.
Madam Speaker, I want to appreciate the chair for that report. Madam Speaker, we happened to visit Ngomeni as a committee of Blue Economy because there is a landing site around that area. And before you get to Ngomeni, the landing site, you pass by the satellite center, the Italian satellite center. And Madam Speaker, I want to tell you, we were there for some days, and the community around that station, Madam Speaker, they are among the poorest in Kenya. Madam Speaker, even the road connecting the tarmac from the tarmac to Ngomeni, there is no even road. Madam Speaker, the landing site in Ngomeni, which we visited, and it was built by the State Department of Blue Economy, there is a water pipeline to the landing site. But you will find that there is a water line to the station, and the community even around that satellite, they don't have water. They don't have water, Madam Speaker, of which I wish the Italian station would just even help the community around there to give them even one water kiosk around that place. So I want to support the report by the Honorable Wanjala, and to make sure that the people of Ngomeni, the people of Malindi, the people of that constituency benefit from that station, Madam Speaker. I want to support, and I hope on the Honorable Wanjala, you are going to follow this report to the letter and make sure that the communities benefit from that station. I support.
Honourable members, we have very many statements that still have to be made by members, so I think we just allow us. Yes, yes. Okay, let us proceed to the next statement.
Order number 8, procedural motion, exemption of business from Standing Order 43.
Majority Leader. My apologies, Majority Leader. Apparently there is a question by member for Turkana North. Is he here? Okay, he's not here. Then we can proceed. Yeah? Okay, Majority Leader, you may proceed with your procedural motion.
Thank you, Honourable Speaker, and I hope that question has been dropped because a member cannot have business lined up in the order paper and is not even in the House. Honourable Speaker, I beg to move that this House resolves to exempt the business appearing as order number 14 in today's order paper from the provisions of Standing Order 43, being a Wednesday morning, a day allotted for business not sponsored by the majority or the minority party, or business sponsored by a committee. Honourable Speaker, as members will note, the order listed as order number 14 is Committee of the Whole House on Critical Government Business, on the Climate Change Bill, the Anti-Money Laundering Bill, the Food and Feed Safety Control Bill, which are lined up for third reading or Committee of the Whole House this morning. That's why the House Business Committee resolved that we have this procedural motion this morning to allow us to transact that business, Honourable Speaker, listed as order number 14. With that, Honourable Speaker, being a procedural motion, I don't have much more to say, and ask the Deputy Leader of Majority to second. I move.
Thank you very much, Honourable Speaker. This being a procedural motion and being a Wednesday, I second the motion and ask that members support so that we can transact the business that is ahead of us. I thank you, Honourable Speaker.
Put the question.
Honourable members, I now propose the question that this House resolves to exempt the business appearing as order number 14 in today's order paper from the provisions of Standing Order 43, being a Wednesday morning, a day allocated for business not sponsored by majority or minority party, or business sponsored by a committee. Okay, is that the mood of the House? Honorable members. Honorable Millie, order. Honorable Millie Odhiambo, please do not shout. Is it the mood of the House that we put the question? The mood of the House that we don't put the question? The ayes have it, so I shall proceed to put the question. Honorable members, I now put the question that this House resolves to exempt business appearing as order number 14 in today's order paper from the provisions of Standing Order 43, being a Wednesday morning, a day allocated for business not sponsored by the majority or minority party or business sponsored by a committee. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? Nay. The ayes have it. And honorable members, if you request in the you don't have sufficient numbers, unfortunately. Let's proceed to... Honorable Nyikal, you're out of order. If you want to make a point of order, just request to make a point of order and we will allow you. Honorable Nyikal, you're out of order. Please be seated. Honorable Nyikal, please be seated. You can request to raise a point of order. Honorable Makalu, what do you want to raise? You can raise your point of order.
You know, Honorable Speaker, with all due respect, we are not opposing this motion. And anytime we say point of order, it is important you allow us to raise the issues we have. What we are saying, Honorable Speaker, the motion on climate change, the bill on climate change, and the money laundering bill were debated in this House yesterday afternoon. Honorable Majority Leader, you have said many times, you listen to proceedings of the House even when you are not in this House. Why do you want to have double standards for members? Why do you want to have double standards for members?
Let him proceed.
It's not a must that I must sit here for me to listen to the House proceedings. And the Honorable Chair, I remember very well, just to confirm I was listening, Honorable T.J. Kagrang did indicate that he would want to move some amendments to this bill. That was said yesterday afternoon. Now, when you bring this bill this early in the morning, on a serious note, understanding orders are very clear in terms of allowing members to have time to move their amendments. What are we doing to this House? Our own standing orders. Madam Chair, I think we have been very unfair to members in terms of their own motions. Today is a Wednesday when we should be discussing private members' bills. Personally, I have a bill which is in the queue. I have not been allocated time to prosecute my bill. And the only time we have, Wednesday morning, then we take it up with the bills which have been rushed through. We need to be serious. That's why we're having agreements in this House, bilateral agreements, which add no value to this country. And we continue supporting them because weka swali.
Okay. What's your point of order, Honorable Millie?
Thank you, Madam Speaker. Madam Speaker, there's a growing trend which is very dangerous in this House. We know that we have a majority in the House, as has been proven even by the ayes. We know we have a minority. But the practice is you let the minority have their say, even as the majority have their way. But the way we are moving in this House is very dictatorial, and we are muzzling members' voices. And sometimes we have very valid issues that we want to raise. We will still have reached the same conclusion, but having had our voices. Madam Speaker, the concern I wanted to raise, which I was not given a chance, is that I have forwarded amendments to 2 of the bills that were subject of that motion. They were subject of that motion, and I'm on a point of order, so the majority leader cannot overrule my point of order. So, Madam Speaker, I have brought amendments to the climate bill, which I've forwarded. I have brought amendments to the food and feed bill, which I have forwarded. So all I wanted to know, because we are moving at supersonic speed. Has the House received my amendments? And are we going to prosecute my amendments this morning? From the history of this House, you know I rarely come to this House in the morning. But I'm here from the moment you started, because I take my work seriously, especially at the committee of the whole House. And I want to correct the majority leader, it's not third reading, it's committee of the whole House. And I want to say therefore, Madam Speaker, that when we are moving at supersonic speed, and we are not giving members a chance to prosecute their own amendment. But I'm on a point of order. How can you overrule my point of order? We no longer have rules in this House. If I'm on a point of order, you do not overrule my point of order, Madam Speaker.
Your point of order, I thought.
Yeah, but that you should not then allow him to stand while I'm still standing. It's unprocedural. Madam Speaker, be very fair. It's very unprocedural. Okay, I will sit down and I follow the rules, but I sit down when you tell me my time is done. But it doesn't stand when I'm standing, whether it's majority leader or heavenly leader. I will not stand when I'm standing. Thank you, Madam Speaker.
Thank you. You've made your point. You'll get a chance. Let us proceed. Yes, majority leader.
Thank you, Honorable Speaker, and I choose to ignore the unnecessary tirade from Honorable Millie Odhiambo, who has her own issues, which have nothing to do with the House or the leader of majority. She can deal with her issues at home, not here. Honorable Speaker, our standing order number 85 is quite clear, Honorable Speaker. We are at order number 8. When I listen, if you can protect me from the spewing of what you can hear from the Honorable Member for Suba something. We are at order number 8, Honorable Speaker. And from the issues that have been canvassed by Honorable Makali,
Honorable Millie Odhiambo,
Honorable Millie.
Honorable Millie, if you continue shouting from there, I will have you leave the House. But please, be orderly. If you do, this is the last warning I'm giving you. Yes. Proceed.
Honorable Speaker, I was saying we are at order number 8. When I listened to what the Honorable Makali, who is a very decent and honorable member, who prosecutes his issues with a lot of decorum and maturity, without having to shout, without having to spew the kind of things you hear being spewed. Honorable Speaker, order number 8 was a procedural motion. We are yet to get to order number 14. If I count, we have another 5 orders before we get to order number 14. So 5 motions, Honorable Speaker. So I was wondering, why are we now jumping order number 9, 10, 11, 12, 13, and prosecuting order number 14? And Honorable Millie is speaking about procedures. Procedurally, you should wait for order number 14 to raise the issues you have on order number 14. The same with my good brother and very good friend, the Honorable Makali. And he knows, that's why you see him smiling. He's not as emotional as Honorable Millie. Because he knows what he's doing is not the right thing. And I would beg, Honorable Speaker, that we proceed with the orders as listed on the order paper, because what I see now is filibustering and trying to waste our valuable time after we woke up very early to be here. And you know, some of us like Millie and myself, myself I'm usually here, but Millie usually comes at 6 p.m. It is now 9, not 6 p.m., Honorable Speaker.
Honorable Member, Honorable Chepkonga, what is it?
Thank you very much, Madam Speaker. Madam Speaker, I rise pursuant to Standing Order number 85, as read together with Standing Order number 83. Madam Speaker, there's a trend in this House where everybody just stands on a point of order. Standing Order number 83 is very clear. Madam Speaker, you must not allow any member, including the member of Kitui Central, who is serving his 3rd term, to shout point of order, and he has no point of order that he's standing on. He's a ranking member. He has not quoted any standing order. I've listened very carefully. I have listened. No, don't worry about my going home. Going home is natural, including going to heaven. That is, in fact, on one day you will go home to heaven. Forget about the one here. Madam Speaker, Madam Speaker, Madam Speaker, I'd like to request you for order of this House, because we will entertain chaos from very senior members, including my very junior member, junior learned friend, Millie Odhiambo. No, you are my junior. I am serving 33 years in the legal profession. You know, you must know that one. She has never appeared. No, she has never appeared, and she has never prosecuted any case. So, so I must say this, Madam Speaker. Madam Speaker, secondly, standing order number 85 is very clear on anticipating debate on a matter that you have not even called. Madam Speaker, secondly, no member should be acting for and on behalf of another member, and particularly the member for Kitui Central. He does not represent Honorable TJ Kajwang. You know, Honorable TJ Kajwang is a lawyer, and he cannot be represented by an accountant unless there's a problem with accounts. He's not an accountant. No, what is he? Or he's an economist. It's even worse. Economists work with assumptions.
Made your point, Honorable Chepkonga. Let us proceed. Let us proceed. Let us proceed. Honorable KJ, have order. No, Honorable KJ, please proceed. Honorable Millie, you are on the last warning. You cannot stand there and shout. You can press the intervention button.
Thank you very much, Madam Speaker.
No, I didn't give you an opportunity.
Thank you very much, Madam Speaker.
I did not give you an opportunity to speak.
You said KJ proceed.
No, I said order, be orderly. Proceed to the next order.
Order number 9, motion. Establishment of a National Cancer Prevention and Control Fund. Question to be put.
Honorable members, I now put the question that aware that Article 42(1)(a) of the Constitution provides for the right of every citizen, every person, to access the highest attainable standard of health, which includes the right to health care services, and further aware that cancer is among the leading causes of death in the country, and noting that although the budgetary allocation for healthcare services is progressive, it is inadequate to cater for cancer prevention and care across the country. Further noting that cancer control in the country is hampered by the inadequate cancer care infrastructure and limited specialized human resource capacity, and recognizing that a significant number of cancer patients do not complete the prescribed treatment due to the high cost of cancer management. Further recognizing that the Cancer Prevention and Control Act of 2012 seeks to promote the access to quality and affordable diagnostic and treatment services for persons with cancer, and to ensure a sustainable capacity for the prevention and control of cancer. This House resolves that the government, through the National Treasury, establishes a National Cancer Prevention and Control Fund to promote prevention, control, and treatment of cancer in the country. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? Aye. The ayes have it.
Order number 10, motion. Development and implementation of a child care program for children whose parents are in lawful custody. Question to be put.
Apologies, Honorable Millie was engaging me, so I got distracted. It's order number 10, yeah? 10 or 9? Question to be put, eh? Honorable members, I now put the question that aware that Article 43(1)(a) of the Constitution, sorry, 10. No, actually my paper is. Is it the one of children? Yes, so you've actually put it as order number 9 on my order paper. Okay, honorable members, I now put the question that aware that Article 53 of the Constitution provides for the rights of children, including the right to free and compulsory basic education, and further aware that Section 22 of the Persons Deprived of Liberty Act and Child Care Policy provides for the care of a child whose parent is deprived of liberty until the child attains the age of 4 years, and recognizing that the children above the age of 4 years still require parental support, and further recognizing that majority of the children often suffer from emotional distress, social stigma, and economic hardships. Cognizant of the fact that all children should be accorded the means of maintaining their relationship with their incarcerated parents, and noting that children have restricted economic resources available for their support, which in turn negatively impacts on their lives. This House therefore urges the government, through the State Department of Social Protection and Senior Citizen Affairs, to develop and implement a program for the care of children above the age of 4 years whose parents are in lawful custody. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it. Your point of order, Honorable Wangwe.
Thank you, Honorable Speaker. Honorable Speaker, I stand on a point of order seeking from you to make it clear whether, Honorable Speaker, the front desk led by the Chief Whip and the Chair Committee on Delegated Legislation are in order, Honorable Speaker, to continue talking while you are reading and you are on your feet. Whether, Honorable Speaker, they are exempt from that decision of the House, or what is the implication of that, Honorable Speaker? Thank you.
Okay, let's proceed. I think they have noted your advice. Thank you. Next order.
Order number 11, motion, national policy on deworming of school-going children. Question to be put.
Honorable members, I now put the question. Sorry, my order paper seems to have been mixed up. It's different from the one everyone has. Okay. Honorable members, I now put the question that aware that Article 43(1)(a) of the Constitution, this is the wrong order. Let me have, this is the wrong order paper. Which one? Honorable members, I now put the question, my apologies for that, I seem to have a wrong order paper. That aware that Article 43(1)(a) of the Constitution provides for every person has a right to the highest attainable standard of health, including the right to health care services, and further aware that the relationship between health and education plays a significant role in school attendance rates. Concerned that the negative effects of poor sanitation, such as parasite infestations, particularly among school children, lead to anemia, stunted growth, and other silent problems, which in turn lead to low school attendance and impact education standards. Recognizing that according to research and school-based deworming is one of the most cost-effective interventions that provides a huge range of holistic and social benefits, such as increased school attendance, healthier kids who do better in school, and while utilizing already existing school structures in administering deworming treatments to school pupils. Recalling that previous programs conducted by the Ministry of Health in partnership with non-governmental organizations called Evidence Action has only been piloted in a few selected counties, and that the deworming efforts have been uncoordinated and dependent on external support, with no clear policy or budgetary framework. Now, therefore, this House urges the national government, through the Ministry of Health, to develop a national policy on deworming school-going children as a crucial part of mainstreaming of health care access in the country. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it. Next order.
Order number 12, motion. Public health concerns at Langata Cemetery. Question to be put.
Honorable members, I now put the question that aware that Article 42 of the Constitution provides for the right of every person to a clean and healthy environment. Further aware that Article 69 of the Constitution obligates the state to ensure sustainable utilization of the environment and natural resources, including land. Recognizing that the fourth schedule to the Constitution assigns the national government the function of land planning, including the general principles of land planning and coordination of planning by counties, as well as matters of health policy. Further recognizing that there is an ongoing public outcry regarding the neglect of Langata Public Cemetery was declared full close to 2 decades ago. Concerned that this matter has been left unaddressed and poses significant health risks to the public. Deeply concerned that this situation has led to overcrowding, double allocation of burial sites, with bodies being buried in shallow graves, leading to frequent uncovering by wild animals from the nearby national park. Further concerned that this has caused untold anguish, pain, and suffering to bereaved families and psychological torment to the neighboring community. Now, therefore, this House urges the national government, through the Ministry of Health, to urgently conduct an assessment of the public health risks posed by the continued use of Langata Cemetery, to institute migratory measures and collaborate with other stakeholders, including the Nairobi City County government, to identify suitable alternative land for use as a cemetery. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it. Next order.
Order number 13, motion. Development and implementation of a program for voluntary regularization of land occupied by squatters. Question to be put.
Honorable members, I now put the question that aware that lack of access to ownership of productive assets, in particular to land, is one of the very serious sources of economic and social insecurity for Kenyans. Further aware that many communities, particularly in the rural income dwellers, and the only way of accessing land in rural income dwellers, the only way of accessing land to put up their dwellings has been to take up residence on land that is unfit for human habitation. Aware that the Bill of Rights in Chapter 4 of the Constitution guarantees every citizen the right to adequate housing and reasonable standards of sanitation, noting that there are very many squatters who have settled on land that belongs to either absentee landlords, unadjudicated land, public land, or community land for long periods of time, with some disputed while others are undisputed. Concerned that the issue of land settlement in many urban areas, particularly in the informal settlements, has remained unresolved, with numerous persons remaining squatters. Further aware that Section 7 of the Limitation of Actions Act of 2010 provides for the right to claim for the settlement on certain land after a prescribed period. Recognizing the need for the Ministry of Lands to hasten the process of identifying parcels of land occupied by squatters where there are no disputes from any party, this House resolves that the government develops and implements a policy of voluntary regularization of land occupied by squatters for a prescribed period, including negotiations for financial settlements across the country to address the challenges facing the said squatters. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? Aye. The ayes have it. Next order. Yes, your point of order. Honorable Nyika.
Thank you, Madam Speaker, for giving me this opportunity. As we move to order number 14, Madam Speaker, I rise to seek your guidance. Because when you come to order number 14, we are going to committee of the whole House. The issues that are being discussed there, starting with number 1, is climate change amendment bill. Madam Speaker, this bill was actually discussed in the second reading yesterday afternoon and concluded actually much late, towards 6, actually maybe after 6. And today, this morning, we have actually sought a procedural motion so that we discuss, we put it in the committee of the whole House. Madam Speaker, this process does not give members opportunity to actually put amendments if they wish to do so. Madam Speaker, if you look at it properly, logistically, by the time we were discussing this bill, anybody who was thinking of making an amendment was already barred because of the time. So what has happened, Madam Speaker, is that at this speed, members do not get the time to actually contribute and even put amendments. Madam Speaker, I myself, I have amendments that are proposed in climate bill, in the climate change bill. Madam Speaker, I'm not sure because I signed them this morning, and when I was signing them, I was told, I was actually advised that as I'm signing them, they are actually already time barred. So Madam Speaker, where then is the time for members to actually put amendment if they wish to do so? If we finish a matter at 7 in the evening and at 9 it is in the House, and it's a bill where there was a lot of contentious issue and the members indicated they wouldn't want to put amendments. I know some people may say that this particular bill has been in the House for some time and one could have put amendments earlier. But the truth is that, Madam Speaker, we come and sit in this, particularly when a bill is being moved. The most important time for a bill is when the mover is actually prosecuting the bill. You get a lot of information from what the mover is saying. You get educated. Other members make contributions. And from that, then members can make their minds as to whether they want to put amendments or not. If that time is not allowed, when then do the members get the time to make the amendments? I have 3 amendments for this. I'm not sure, as I see here, they are not in the order paper. So I would actually propose, Madam Speaker, that you actually give direction. Madam Speaker, just give me time.
No, I just want to explain to you that your amendments came after the order paper had been printed, but it was approved.
Thank you very much. And it will come.
Yes.
And Madam Speaker, while I thank you for that.
And many people actually brought in their amendments, despite you saying that there wasn't enough time. I was surprised that I had, I think, 10 early this morning. By 8 o'clock, they were at my desk for approval. But
thank you very much, Madam Speaker. I like that. But I again, as I thank you, please, you approved them, but you actually threw them out of time, which is a good thing you did. But let us not run the House in such a way that sometimes, even from the important seat of the Speaker, we have to do things out of order because we did not follow the procedures. I thank you for that, but we are seeing a trend that will make it difficult. Madam Speaker, let me make a point. And then I'm
misleading the House.
I've thanked you.
Honorable Nikali,
but let me make this point.
None of those were approved out of time. They were within time. We just said that the printing, yours particularly, by that time it had been printed. So what you're canvassing has already been overtaken by events.
I agree, Madam Speaker, but let me just make this last point and thank you again. Madam Speaker, supermajority is good because it can make the executive do a lot of good things for the country in good time. But it is a double-edged sword, because it can also make the executive do very many bad things very quickly if in a situation as we are. But for this particular one, I thank you. But the process I've said, keep in mind, Madam Speaker. Thank you very much.
We have at all times stuck to the process. So I think we'll move to the next order. Point of order, Honorable Millie. At least now you're being polite. Proceed.
Madam Speaker, I think you also need to understand God endowed us very differently. There are people who speak softly. Some of us were not born speaking softly. So with my loud voice, it is not rudeness, it's just the way I was born. So please be used to my voice. I just wanted to find out whether my amendments are in for the climate change and for the food and feed.
I must congratulate you. I did sign the approval very early this morning. So
thank you, Madam Speaker.
And that's why I'm saying, Honorable Nyikal, you can see members have been active. They all brought in their amendments despite the short time.
Yeah, so, though for the money laundering, I didn't have the time. Madam Speaker, just finally, just for record, because sometimes when things are not put in order, that's what I wanted to raise. I wanted to remind my honorable member for Anabkoi that I'm actually senior. You know, as a lawyer, you know what it means. I was sworn in before him. So I'm a senior. And I've been a litigation counsel, state law office, Federation of Women Lawyers, the Cradle the Children Foundation. Litigation means court going. I'm sure he doesn't know.
Thank you. Honorable members, allow me to recognize visitors who are at the public gallery. The church group Neno Evangelism from Laikipia West constituency, Laikipia County. Also seated in the public gallery is Higher Calling Church Group from Laikipia West, Laikipia County. I also wish to recognize, seated in the speaker's gallery, students and teachers from St. Joseph's Primary School from Dagoretti South constituency, Nairobi County. On my own behalf and that of the entire House, I wish to welcome you to Parliament. Thank you. Next order.
Order number 13. Order number 14, Committee of the Whole House.
Where's the mic? Honorable members, we are already in the committee of the whole House, and we will start with the Climate Change Amendment Bill, National Assembly Bill number 42 of 2023, as in the order paper. And as you've been informed, where amendments are not in the order paper, they have been approved, all of them shall be considered when reached. So we'll start, honorable members, and I request that all of us, order members, order. I'll request that all of us be keen at this stage, because this is really the crux of the work of this House. In lawmaking, this is the most important part because we go clause by clause. So, honorable members, I request you to be very keen, especially those who have amendments to the various bills to be considered this morning, so that we don't reach you and you're not ready. Thank you.
Clause 3.
Honorable members, clause 3 of the climate change bill has no amendment, and I therefore go ahead to propose the question that clause 3 be part of the bill. If there are no takers, I now go ahead to put the question that clause 3 be part of the bill. Will as many as are of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it.
Clause 4.
Honourable members, I proceed to propose the question that clause 4 be part of the bill. This the clause 4 of this bill has two proposed amendments by the Honorable Millie Odhiambo and Honorable Nyikal. They are both proposing deletion. Honorable Millie Odhiambo, this is your chance.
Thank you, Chairman, for giving me this opportunity. Chairman, I propose...
Just hold. The Honorable Kangogo. Honorable Ruku, please take your seat. And I want to request members all the time, not now, but all the time, whenever someone is a member is speaking, you should always not come between the person speaking and the speaker. I see that happening every day. Go ahead.
Thank you, Mr. Speaker. My point of order is that the members who have proposed amendments to various sections, it is not in this order paper. We are seeking, Mr. Speaker, if there is a supplementary paper so that we understand, even prior to that amendment, what these other members are seeking. So we seek your intelligence that be provided.
The proposed amendments by members have been circulated. The ones that are on the paper have been circulated as I speak. So they're going to reach you just now. But the effect of the amendments being proposed by Honorable Nyikal and Honorable Millie Odhiambo is to delete clause 4. So, is it a point of order or? Okay, the Honorable Wandai.
Just for good order. Just for good order, Mr. Chair.
No, she's not.
Mr. Chair, if you could listen to me, I know that lucky if you say the proposed amendments are coming in a short while, how long is a short while? Because we can't proceed with this unless we have them on our desks. We need all the proposed amendments on our desks, so that we can be able to prosecute them appropriately. So we can still take time and wait for them to come. There's no hurry. The world is not ending today. There's a hurry. No, we can just take time, good time. Mr. Chair, yes.
I'm aware that as we speak, the amendments, the Honorable Chungwa, point of order, I've said that the proposed amendments that are on the order paper are being circulated. I request members to be patient on their seats. These are going to come to you. In any case, I've just said that the proposed amendment for clause 4 is for deletion. Yes, Honorable Makali.
Yeah, thank you very much, Mr. Chairman, Honorable Chairman. You know, Honorable Chairman, we did raise some fundamental issues earlier. And the majority leader and the Honorable Chepkong just took it casually. Mr. Chairman, the truth of the matter is the reason why there's a requirement for the order paper to be published a number of hours to the day of the debate is to be able for the members to prepare themselves. And even when you say we are approving these amendments in the morning, Honorable Speaker, Honorable Chair, we need to note that the reason why we have standing orders is to have a well-structured way of doing our business as a house. So, Honorable Speaker, Honorable Chair, in a situation where you want us to debate amendments, and they are not in this order paper, I appreciate the fact that they are being circulated. But even after being circulated, Honorable Chair, you realize, still, for you to internalize those amendments, and if you want to do any research on them, there is no time. So today we can agree that we want to do things the way we are doing them. But I think for the future, Honorable Chairperson, for the future, and for the good way of conducting business in this house, we need to stick to our rules. I submit.
Members, I have to make this very clear. Honorable Makali and I have been in this house for the last 3 terms now, and we know that this is not the first time members will be requesting the Speaker to approve the amendments, even when amendment is already being on the floor. So many times you've had your amendment being approved by the Speaker, even when a matter is in the floor being debated. So let's not split hairs on this matter. The Speaker already ruled on how we are going to proceed. So I will not entertain any further points of order on this matter. We shall proceed as per the order paper. The Honorable Milo Odhiambo.
Thank you, Chairman. Chairman, I propose that clause 4 be amended as per the order paper. And the essence of the amendment, Chair, is that what the proposed amendment by the majority leader does in effect is to remove the issue of public participation as is contained right now in the schedule. And what I'm seeking to do is to retain the elaborate public participation on issues of climate change as proposed, as contained in the current act. I therefore propose, Chair.
Majority Leader.
Chair, I rise to support that amendment by Millie. And
order. Just take your seat for a minute. Yeah. All members, I propose the question that clause 4 be amended as proposed by Honorable Millie Odhiambo. Yes, Honorable Majority Leader.
Sorry, Chair, I rose even before you proposed. I was saying I rise to support that amendment, the amendment by Honorable Millie, and is similar to an amendment that the Chair also has. So if it passes, then we are good, because it is buttressing what is already provided for in our Constitution, that public participation is cardinal to everything that relates to our people. And therefore, I support. And you can put the question.
The Majority Leader, you need to consult with the Chair, because the Chair is proposing to do something different from what you just said. Honorable Nikal.
Thank you, Chair. I had a similar amendment, which means that if this amendment is concluded, the same will apply for my amendment. But, Mr. Speaker, I proposed a similar amendment. I support. We cannot hurry when we are making laws to kill the laws that very pertinent to our Constitution, like public participation. I said yesterday, we are hurrying this law, and it is to no good. I therefore support that section be deleted. I support the amendment.
Chair of this committee. And remember, we are prosecuting.
Thank you. Yeah. Yes. Honorable Speaker, first of all, I want to thank Mheshimiwa Honorable Millie, Member of Parliament kutoka Suba, and I agree with her. She went through the bill, she read and she understood, and we totally agree that, as Majority Leader said, The cardinal aspect of this country's legislation is public participation, and we totally agree with her. Mine is different, to move another within. It's just a typo, not on what really the difference. Thank you, Honorable Speaker.
Okay, honorable members, I therefore put the question that clause 4 be amended as proposed by Honorable Mili. Will as many as of that opinion say aye? Aye. Will as many as the contrary opinion say nay? The ayes have it. The effect of that amendment, therefore, is that the chairperson of the committee cannot move his amendment because there's no clause further to have an amendment to be amended. I now put the question that clause 4 as be deleted as proposed by the Honorable Mili. Will as many of that opinion say aye? Aye. Will that of opinion say nay?
Clause 5.
I propose a question that clause 5 be part of the bill. Members, clause 5 has no amendment. I go to put the question that clause 5 be part of the bill. Will as many other opinion say aye? Aye. Will as many other opinion say nay? The ayes have it.
Clause 6.
I propose the question that clause 6 be part of the bill. There's a proposed amendment by Honorable Nyikal and Honorable Mili and Honorable Chairperson. So we'll start with Honorable Nyikal.
Thank you, Chair. I propose that clause 6 be amended as in the order paper, and the import of this amendment, Chair, is that we delete the whole of 6, because what the whole of 6 is doing is actually amending clause 6 of the section 7 of the bill, which is about members of the council that are proposed. And my reasoning, Chair, is that if you look, the composition of the council as it is, the council will be nominated as follows: cabinet secretaries responsible for environment and climate, cabinet secretary responsible for national treasury, cabinet secretary responsible for economic planning, cabinet secretary responsible for energy, the chairman of the council of governors, a representative of the private sector nominated by a body representing the largest number of private institutions, a representative of the civil society nominated by the most representative registered national umbrella association of civil societies, and C, a representative of the marginalized community within the meaning of Article 26 of the Constitution, who has knowledge and experience in matters relating to this, and a representative of the academia nominated by the Commission of University Education. What the bill is intending to do, Chair, is that all the cabinet secretaries, they stay in the bill, but when you come to the persons that are actually stakeholders, representative of private sector nominated by the body representing the largest number of institutions in the private sector, what happens there, Chair, is that after private sector, the rest is actually deleted, which means that the private sector will not themselves now appoint or select or identify. That will then be identified by the president. The same thing when you come with the civil society, again, the civil society themselves will not nominate, select, or appoint. That will be appointed, selected by the president. When you come the commission of academia, again, they will not be nominated by the Commission of University Education. Chair, what you end up with, the whole council is actually nominated by the president. I know there's a saving grace that is being put there, that all this will be brought to Parliament for vetting. But Mr. Speaker, if you have an institution where all the council members are actually nominated by the president, you are just making it a department of the government. It ceases. The stakeholders have no say, because the stakeholders are actually indebted to the person who has appointed them. Even though they are representing their various institutions, the institutions didn't bring them in. So with that, Mr. Speaker, we are weakening this council to an extent that actually it will just be an arm of the government. In fact, it will be an instrument of the president. That may be good, that the president has sole power on it, but really the president needs varied views from various stakeholders to make a decision. So, Mr. Speaker, on that, I propose that we delete this and leave the council as it was in the previous bill. Thank you, Chair.
Thank you so much. Members, I propose a question that Clause 6 be amended as proposed by Honorable Nyikal. We'll come to you as Honorable Millie. I now put the question that Clause 6 be amended as proposed by Honorable Nyikal. What's out of order, Honorable Millie? We are coming to you as. You know, the effect of this question I'm putting is that if it's carried, then yours become negatory. That's the point I'm trying to make to you. So allow this to be done, then in case it's carried, then you achieve what you want to achieve anyway. So I will put the question that Clause 6 be amended as proposed by Honorable Nyikal. Will as many as are of that opinion say aye? Aye. Will as many of the contrary opinion say nay? Nay. The nays have it. Honorable Millie.
Thank you, Chair.
Yes. Yeah, Honorable Millie, take your seat for a minute. Because the Honorable Chair had amendments. So, Chair of the committee. Honorable Millie, just allow a minute so that the Honorable Chair of the committee. Yeah. My life is already easy, Millie. Just give me a minute, Honorable Millie. 1 minute. You're going to come. So, Honorable Chair of the committee.
Honorable Chair, thank you, Honorable Chair. I beg to move. I beg, Honorable Chair, to drop this amendment that is ours on Clause 6, because we were proposing to have 2 nominees from the private sector. But again, when we looked at the numbers, we are going to have an even number, which is not right. So we are dropping this to retain the way the bill is, to have the way the bill is. But I have the amendment on Part 5 of 6, where we are not agreeing with the bill, where we are saying Article 260. Where the marginalized is appointed, we are deleting that and retain as the original, as the way it is in the original bill. Thank you, Chair.
So, Chair, then would you therefore move the amendment you're proposing for subparagraph 5?
Thank you, Honorable Chair. I beg to move that subparagraph 5 be deleted as per the order paper, and the justification for that, Honorable Chair, is that we don't want to affect any constitutionality of an amendment where if you remove the marginalized is nominated as per Article 260 in the Constitution. So again, when we delete and we say that the president can appoint without taking into consideration Article 260, then I think that is unconstitutional. So we are deleting subparagraph 5 of Section 6. Thank you, Honorable Chair.
Thank you. I therefore propose the question that clause 6 be amended as proposed by Honorable Gikaria, Chairperson of the committee. I now put the question that clause 6 be amended as proposed by Honorable Gikaria. Will as many as that opinion say aye? Aye. Will as many as contrary opinion say nay? The ayes have it. Then, Abomili, this is now your chance to move your amendments with the rider that you will not move on what has just been deleted. Go ahead.
Thank you, Chair. Chair, this is actually where I'd wanted to make your life easier. I'd wanted to indicate that the import of the amendments that have been defeated by Honorable Nyikal actually affects some of my amendments. And that affects my amendment to 6A2, which is on the private sector. So therefore I dropped that because I'd wanted to retain the private sector to have a say. Secondly, I also will drop my proposed amendment to 6A3, which also retained the voice of civil society, but which has also failed through Nyikal's amendment. And then, Chair, if you notice also, I'd actually tried to speak to the amendment by the chair of the committee, because I had a similar amendment, but for slightly different, other than the constitutional issue, but also because of the issue of indigenous knowledge. And I'll give you an example, Chair, that, for instance, in my constituency, you have old men who can tell you weather patterns. They will tell you that it is going to rain when there is no sign of rain. And they are not witches, it's just years of experience. So because that has been carried, my proposed amendment is carried. And then, Chair, for 6, also by nomination by the Commission of University Education, by the failing of Honorable Nyikals, I therefore drop mine. And then finally, Chair, for 6B was not moved by either, but it's not that important. I think I can drop it. The ones that were very keen for me, some have been carried, some have not been carried. I'm okay. So I dropped the ones which were remaining. Thank you, Chair.
Thank you for making my life more easier. I therefore now put the question that clause 6, as amended, be part of the bill. Will as many of that opinion say aye? Aye. Will as many of contrary opinion say nay? The ayes have it.
Clauses 8 and 9.
I propose the question that clauses 8 and 9 be part of the bill. There's no amendment.
Oh, sorry. Go back.
Sorry, we go back to 7. Yeah, the Honorable Nyikal has an amendment on 7.
Clause 7.
The Honorable Nyikal.
Thank you, Chair. I propose that clause 7 be amended as in the order paper. And Chair, what that means, in the order paper, it is indicating that section 8 of the Act is amended in subsection 2 by inserting the following new paragraphs immediately after paragraph E. Chair, if you go to section 8, it is the powers of the Cabinet Secretary. And as it is in the Act, the cabinet secretary shall formulate and practically review climate change policy, and that's okay. Coordinate negotiations on climate change, that's okay. Formulate a national agenda, and that's okay, up to E. And then what this does is now adding a whole slate of in the powers of the cabinet secretary, which is one, to advise the council on the carbon budget for trading based on Kenya's international obligations. Here is a bit of a reversal of what we know of councils. Quite often these councils, they actually advise the cabinet secretaries. This is actually the reverse. Approve international matters, transfers of mitigation, approve measurements, reporting, and this, authorize the establishment and reduction of emissions from the deforestation and so on. Chair, it is the basic principle that what this bill does, first of all, the appointment of all the council members was basically an executive affair. And now, the cabinet secretary has basically all the powers that you would expect the council to have. So in that case, as I said earlier, Chair, it would have been just wiser to forget about this bill and create a directorate under the Ministry of Environment. So if we do this, the council will actually be rendered completely powerless because the minister will be doing everything. So, Chair, I then propose the amendment to delete that section 7. Thank you, Chair.
Thank you. I propose the question that clause 7 be deleted as proposed by Honorable Nikal. I now put the question that clause 7 be deleted as proposed by Honorable Nikal. Will as many as other opinion say aye? Will as many of the contrary opinion say nay? Nay. The nays have it.
No, not deleted, the nays. So you say,
I now put the question that clause 7 be part of the bill. Will as many of that opinion say aye? Will as many of the opinion say nay? The ayes have it.
Clauses 8 and 9.
I propose the question that clauses 8 and 9 part of the bill. I now put the question that clauses 8 and 9 part of the bill. Will as many of that opinion say aye? Aye. Will as many of the opinion say nay? The ayes have it.
Clause 10.
I propose a question that clause 10 is part of the bill. There's an amendment by the chair of the committee on environment for this amendment.
Thank you, Chair. This is just a typo. Honorable Chair, I beg to propose an amendment, clause 10 of the bill, amended by inserting the following new paragraph after the opening statement in subsection 3 by deleting the word county appearing in paragraph A. This is just a typo, Honorable Chair. Thank you. Country, not county, sorry.
I bet this is straightforward. It's just substituting county for country. So I propose the question that clause 10 be amended as proposed by the chairperson of the committee. I put the question that clause 10 be amended as proposed by the chairperson of the committee. Will as many of the opinion say aye? Aye. Will as many of the opinion say nay? The ayes have it. I now put the question that clause 10 be part of the bill, as amended part of the bill. Will as many of the opinion say aye? Aye. Will as many of the opinion say nay? The ayes have it.
Clauses 11 and 12.
Members, I propose that the question that clauses 11 and 12 be part of the bill. I now put the question that clauses 11 and 12 be part of the bill. Will as many as another opinion say aye? Aye. Will as many as another opinion say nay? The ayes have it.
Clause 13.
I propose the question that clause 13 be part of the bill. It's amendment by the chairperson of the committee. 13. Clause 13.
Thank you, Chair. I beg to move I beg to propose that the bill be amended by deleting clause 13 and substituting with the following new clauses. There is a new clause that, do I read the whole bit? That's supposed to come later. Honorable Chair, I need your guidance because we are deleting 3, but we have a new clause that as contained in the order paper.
Just move the deletion. The one will come to the other one later.
Honorable Chair, I beg to move that the bill be amended by deleting clause 13 and substituting there with the following new clauses. Thank you, Honorable.
Honorable Chair, you're moving to delete, so stick yourself to amendment of clause 13.
Sorry, Chair. I beg to move that the bill be amended by deleting clause 13 and substituting with the new clauses as per the order paper. Thank you, Honorable Chair.
Honorable Chair, read the amendment as it appears in the order paper now. For 13 only.
Sorry, because I'm using some papers which I was given. Sorry, Chair. I beg to move that the bill be amended by deleting clause 13 and substituting that with the following new clauses. Section, that is 4, subsection 4, section 24 of the Principal Act is amended by deleting subsection 3. Thank you.
I propose the question that clause 13 be amended as proposed by the chairperson of the committee.
Chair, can the chair of the committee explain to the House what is the import of that amendment? Why is it necessary so that we can participate?
Honorable Karia.
Honorable Chair, it has been said here, and Millie agreed with us, and the majority speaker did agree. It's about the public participation. Honorable Speaker, public participation is a constitutional requirement, and it is the fundamental issue that every Kenyan should be given an opportunity when this kind of legislation or whatever is happening within the legislative framework. So this one is just to delete what the bill had intended to remove, the public participation. But we are going now to later to bring in the few, instead of the 60 days that is there, we will be moving a new clause to reduce it to around 28 days. Thank you, Honorable Chair.
Thank you. I now put the question that clause 13 be amended as proposed by the chairperson of the Committee of Environment. Will as many of the opinion say aye? Will as many of the opinion say nay? The ayes have it. I now put the question that clause 13 be part of the bill. Will as amended part of the bill. Will as many of the opinion say aye? Will as many of the opinion say nay? The ayes have it.
Clause 14.
I propose a question that clause 14 part of the bill. There's an amendment by the chairperson of the committee. Chairperson.
Thank you, Chair. I beg to move that the bill be amended by deleting clause 14 and substituting therefore with the new clauses. That is section 14. Section 36 of the Principal Act is amended in subsection 2 by inserting the new paragraphs immediately after paragraph B. BA, the regulations of carbon market. BB, the regulations of carbon trading. BC, the regulations of carbon registries. And lastly, BD, the regulation, sorry. Let me start. BA, the regulation of carbon markets. BB, the regulations of carbon trading. BC, the regulation of carbon registries. And BD, the regulations of non-market approaches. Thank you, Robert Chair.
I now propose a question that clause 14 be amended as proposed by the Honorable Gikaria. I put the question that clause 14 be amended as proposed by the Honorable Gikaria. Will as many as are of that opinion say aye? Will as many as are of that opinion say nay? The ayes have it. I now put the question that clause 14 as amended be part of the bill. Will as many of that opinion say aye? Will as many of that opinion say nay? The ayes have it.
Clause 15.
I propose a question that clause 15 part of the bill. Chairperson of an amendment.
I beg to propose that clause 15 of the bill be amended in the proposed new section 23B by inserting the words in accordance with the relevant carbon standards immediately after the word time appearing in paragraph C. B, in the proposed new section 23E by inserting the words environmental immediately after the words improve the appearing in subsection 7, and C, by inserting the following new sections immediately after the proposed new section 23H, that is 23I. This designated national authority shall charge such fees as may be prescribed by the Cabinet Secretary in regulations for proper administration of the Act. Honorable Speaker, do I read the justification?
Part of why you give you a chance is to explain what you are amending. Just explain the input of the amendment.
Thank you. The justification of the amendment is the amendment seeks to ensure that carbon offset projects emissions are kept out of the atmosphere for a reasonable length of time in accordance with the relevant carbon standards. Carbon projects aimed to improve environmental and, in addition, to economic, social, and cultural well-being of the community around the projects, and that the Cabinet Secretary makes regulations with regard to matters touching on certain carbon trading in line with Article 94, subsection C of the Constitution. Thank you, Honourable.
Thank you. I propose. Before I propose that amendment, the chairperson had a further amendment, which I would ask him to now move so that I propose them together.
Oh, there you are. Thank you. That the clause 15 of the bill be amended in the proposed new section 23G by inserting the following new subsections immediately after subsection 3. The National Carbon Registry shall be accessible to the public. Of course, Honourable Chair, under the access to information, Honourable Chair, we cannot have a registry that is not accessible to the public, so we are making this a condition that this information of the registry is available to the public as and when they make that request. Thank you, Honourable.
Thank you. I now propose the question that clause 15 be amended as proposed by the chairperson of the committee.
Whereas I support A, B, and C, which the chair has explained, and I wish the chair could listen to me, whereas I support A, B, and C, which, particularly A, B, but he also amending the 23I, which he has not explained. He explained 23H. But what I get there is, again, what is happening here is the cabinet secretary has put the regulations, and you see once again the national authority actually is to a large extent really not doing much, because even here what you are seeing, it's tied with what the cabinet secretary has done. So I actually oppose that, but A and B and C I support, and I would propose, Chair, that these are actually called separately, because I may support A, B, or C, and I may not support another one, to enable us to distinguish each and support or oppose appropriately.
Thank you. The Honorable Makali.
Yeah, thank you, Chairperson. On this issue of access to the registry being accessible to the public, I thought it's like this House did pass a law in terms of access to information and all that, so that maybe, although we're just emphasizing here, but there's a general understanding that so long as it's public information, it should be accessible to every Kenyan. So even as I support it, I think that is just a fact that it must be accessible to the public.
Thank you. Members, I now put the question that clause 15 be amended as proposed by the Honorable Gikaria. Will as many as are of that opinion say aye? Will as many as the contrary opinion say nay? The ayes have it. I now put the question that clause 15 as amended be part of the bill. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it. Before we proceed, I wish to recognize pupils from Highland Education Center Primary School, from Tarbo in Uasin Gishu constituency, and students from Njenga Karume Secondary School, Molo in Nakuru County. They are welcome to follow our proceedings this morning, and I request members to join me in welcoming them to the House today. Thank you.
Clause 16.
I propose the question that clause 16 is part of the bill. Honorable Nikal, now you can prosecute a point of order.
Chair, my point of order is not on 16. The practice has been, and I think you know this and we all know it, that where you have an amendment that has many parts, it is actually better to call them in different parts. You notice Honorable Millie had to now struggle to look at parts that have been passed and parts that she wants to support. So if you put it blanket, then how does a member find out, now I want to support this bit and I don't want to support this? So I just want to bring that to your notice, that as we go on further, where there are several amendments, they should be called differently, each one, so that we can participate. Thank you, Chair.
But Honorable Nikal, if you look at clause 15, it had no parts. It had no parts, and the order. It had no parts, and the amendment that was given by the chair is a block amendment. That's why. So, of course, we always do that, but this amendment, if you look at clause 15, it had no parts to be chunked into pieces and be moved separately and differently. The Honorable Milius, what's your point of order?
Chair, just so that we move together, we are at clause 16.
Yes.
And clause 16 is proposing an...
Allow the mover to move it first before then you...
Is it a proposed deletion? That's what I want, because I don't have the...
Allow the person who wants amendment to move the amendment first. Then you come back.
Because then I'll come with my point of order.
Yes, that's okay. So the chair...
Thank you, amendment. Thank you, Honorable Speaker. I beg to move that the bill be amended by deleting clause 16, but move a further amendment, Honorable Chair, that the bill be amended by deleting clause 16 and substituting thereof with the following new clauses. That the schedule to the Principal Act be amended in section 1, subsection 2 by deleting the word 60 appearing in the paragraph E and substituting thereof with the words 28. Honorable Chair, the justification of this is that as a committee, Honorable Chair, we are not agreeing with the ministry to delete public participation, but we are, as a committee, the ministry did justify that 60 days it takes too much time for them to be able, so they are requesting that we have moving a further amendment that we move it from 60 to 28 days, which is a justifiable time for, of course, enhancing the speed at which we will be able to address some of these issues, but we are retaining public participation. Thank you.
The Honorable Chair, approach the table. Sorry, members, the consultation is to make sure that we do the right thing. So, Chairperson, go ahead to move the amendment on clause 16.
Honorable Speaker,
as per the order paper,
I beg to move that the bill be amended by deleting clause 16 as per the order paper, and as per the order paper. And there is a schedule that we want to amend, a further amendment on the schedule, that the bill be amended by deleting clause 16 as per the order papers, and substituting the schedule of the principal, of the principal act as per section 1(2) by deleting the word 60 appearing in paragraph E and substituting thereof with the word 28. Thank you, Honorable Chair.
Thank you. I propose the question that clause 16 be amended as proposed by the Honorable Gikaria. Majority Leader.
Thank you, Honorable Speaker. I want to support that amendment. Honorable Speaker, just to make clear, the bill had proposed to delete the schedule on public participation. So the deletion is what Honorable Gikaria is proposing, so that the schedule remains. Then he moves a further amendment that amends the schedule, reducing the number of days for public participation from 60 days to 28 days. And I support.
Thank you so much. The Honorable Nyikal.
Yeah, again, this is one where we could actually call in two, but I think it may not be necessary. Yeah, the principal issue that comes here is that we are fighting public participation in any way we can. We removed it in 4, so deleting it in 16 makes sense. But then you say, okay, even if you are going to do it, we won't allow you those many days. It is 20, so 28 days. We're making it perfunctory, just that there is. So I oppose the deletion. Now, if I want to oppose the changing of 28 days while I support the other one, how do I do it? Because I want 28 days to be removed to remain as it is. This is what I was saying. Sometimes you have to now look. I agree it should be deleted, but 28 days should be, I want 28 days to remain 60. What guide me on how to do that?
This is the guidance there.
Yes, Chair.
If you had been keen, you'd have then moved an amendment to retain it at 60. That's what should have happened.
Chair, therefore, with your guidance, and there are times that it is allowed to do this on the floor, I therefore going to be given time to move that to amend the amendment so that 60 days will stay as further amendment.
You don't have to do that. You just have to vote against it. That's it. Honorable Makali.
You know, Chairperson, what is happening? We are in agreement. We need to have public participation, and I think what we are saying is the time being allowed for public participation. If we are really serious with public participation, 28 days might be not enough. So I'm pleading with the chairperson of the committee, because he's the one who's moving the amendment, to change the number from 28 possibly to 40 or 45 days, so that we're also fair to the public. We are talking about public participation in the whole country where need be. 28 days would be such a small number that it might not be fair. But if we want to be effective public participation, Honorable Gikaria, I plead with you, because you are the mover.
Thank you.
Move it to 45
Thank
days.
you. Honorable Mili. Honorable Ichungwa.
Thank you.
Allow Majority Leader a minute, Honorable Mili.
Sorry, Chair, to interrupt, but on a point of order, I think you probably did not get the gist of the argument by Professor Nyikal. You were asking if the way in which Honorable Gikaria has moved that particular amendment, Honorable Nyikal is okay with the first part of deletion.
Yes.
Then he has a problem with the further amendment.
Yes.
So I wanted to propose, can we then first vote for the first part of the amendment as it is on the order paper, then vote for the further amendment, so that where Nyikal and Makali don't agree with the chair, then they can vote in the negative. Isn't it? And I think
Okay.
we'll be sorted that way.
We will give that indulgence at the right time. Honorable Millie.
Thank you, Chair. Chair, of course, I also want to join Honorable Nyikal and Mekali that I support the amendment as per the order paper. Chair, I'd request to borrow your ear. Chair, I know that men are not very good at multitasking. So I beg to borrow your ear. Thank you, Chair. Chair, I just want to request that, and agree with Honorable Ichungwa, that if we can move by section, so that, because we are supporting the first part which retains public participation. However, I want to make a further appeal to you, because this process, as you already know, because of the time constraints, it may not be possible, especially because the chair has just moved a further amendment, which we are not aware about. Because then we would have done an amendment with amendment. I would actually encourage that you allow us, personally I wouldn't want to say to put it at 60, but to meet somewhere in the middle that we put it at 40. If you can allow us to bring a further amendment to the chair's amendment so that we put it at 40, because then it becomes meaningful participation. So Chair, with your indulgence, because it happens all the time, we can bring amendments here and we bring to you and you approve. If you can allow Honorable Nyikal to bring an amendment to put it maybe to 40 days, and I persuade Honorable Nyikal to move away from the 60 to 40. Otherwise, I support the earlier, the amendment as per the order paper of 16 to retain public participation. Thank you, Chair.
Honorable members, if you have been following, I will guide as follows, that we'll vote on the chair's amendments twice. We'll vote first on the first amendment, then after that we'll vote on the further amendment. I will also allow the Honorable Nyikal to bring a further amendment to the Honorable Gikaria's further amendment. So therefore, honorable members, you know, the house of rules and we always have to follow rules. If you look at the order paper, there's only a single amendment on clause 16. And if therefore we vote on that clause and we carry it, then there will be nothing existing for us to carry Honorable Gikaria's amendment and even the further amendment. And therefore, Nyikal, now we go back to what you said earlier, that there are times when you have to move the question together. This is one of the times when, if you don't move it together, we will not have any foot to stand on to move the further amendment. And therefore, allow me, Honorable Nyikal, I will therefore want us to put the question together. But before we do that, I will allow the Honorable Nyikal to move his further amendment, to the Honorable Gikaria amendment, about the days. So go ahead. There's Honorable Millie. Honorable Millie, go ahead.
Yeah, Chair, you do realize, because I know you are one of the diligent members, that at this stage, sometimes we persuade each other.
Yes.
If Honorable Nyikal moves his amendment and it is not popular with the majority, it will fail.
Yes.
If they agree, then it would be better for the chair himself to move the amendment instead of Honorable Nyikal.
I will give the Honorable Nyikal, the Honorable Gikaria, and the Majority Leader 1 minute
to talk to each other 1 minute so that we can move together. Yeah.
The Honorable Gikaria. This isn't a Bomas matter. It's a very small matter. This doesn't belong to Bomas. We just clear it and we... Okay, great. Great. So now... I now put the question, members, that clause 16 be amended as proposed by the Honorable Gikaria. Will as many other opinions say aye? Aye. Will another counter opinion say nay? The ayes have it. And now I'll put the question, members, that clause 16 as amended be part of the bill. Will as many other opinions say aye? Aye. Will another counter opinion say nay? The ayes have it.
New clauses, new clause 13A.
The mover to the new clause 13A, Chairperson.
Thank you, Honorable Chair. I beg to move that the bill be amended by inserting the following new clauses immediately after clause 13. New clause 13A, the bill be amended by inserting the following new clauses immediately, section 13A. Section 33, the Principal Act is amended by inserting the following new subsection immediately after subsection 1. 1A, a person who, A, willingly conducts an authorized trade in carbon credit.
The Honorable Gikaria, you are going well, but if you could just start your statement by saying that the new clause 13A be now read a second time, then you proceed to explain.
The new clause 13A be read a second time. That section 13A, section 33 of the Principal Act is amended by inserting the following new subsection immediately after subsection 1. 1A, a person who, A, willingly conducts an authorized trade in carbon credit, B, knowingly gives false misleading information with respect to environmental or financial gains from the carbon market investments, C, manipulates carbon credit measurements in order to gain additional measurements, D, engages in money laundering through carbon trading, E, knowingly sells carbon credit.
The Honorable Gikaria, I would propose just explain. You don't have to read every section. Just explain to us the import of the amendment and we proceed.
The import of the amendment, Honorable Chair, is that the amendment seeks to provide offences and penalties with respect to the carbon market, which had not been provided for. Thank you, Honorable Chair.
Thank you, members. I now propose that the question that the new clause 13A be now read a second time. Don't Lebonyikal, 1 minute.
Chair, I know they're looking tense. I support this because we have to actually put sanctions.
Thank you.
Carbon trade is going to be a very important issue and can be abused. And these are addressing such abuses. I support.
Thank you very much, Chairman. Chairman, I support this amendment. It's very important because the carbon credits are being misused and it's being used for money laundering. So I support the Chairman.
Thank you. And now put the question that the new clause 13A be now read a second time. Will as many other opinions say aye? Aye. Will as many other opinions say nay? The ayes have it. I now propose the question that the new clause 13A be part of the bill. 1 minute.
Yeah, thank you, Mr. Chairman. Mr. Chairman, just as I support this amendment to be part of this law, I know this drafting issue, but the issue of not exceeding, the fine looks very good, 500 million shillings. The sentence of 10 years looks very good, but when you say not exceeding, it means you can even do 0, and I think really, this is a matter to me I think we need to think through, because I don't know how it should be done, but I thought would have been more specific in terms so that it becomes like a deterrent issue. But I support.
Thank you. I now put the question, members, that the new clause 13A be part of the bill. Will as one other opinion say aye? Will as one other opinion say nay? The ayes have it.
New clause 13B.
A mover, the chairperson of the committee.
Honorable Chair, I beg to move that clause 13B be read a second time. Section 35 of the Principal Act is amended, A, by numbering the existing provisions as subsection 1, and B, inserting the following new subsection immediately after subsection 1, that is subsection 2, 3, 5, 7, 10, and 15 of this Act shall not apply to entities that have existing carbon projects for a period of one year. Honorable Chair, the justification for this is that the bill had not provided. Already we have existing players, investors, that if you don't give them this transition period, then maybe the Act might come and render them not in business. So what we have agreed to do is that we are giving a provision of 1 year for them to be able to comply with the new Act, and then they can continue so that we don't stop investors from going on with their business. Thank you, Honorable Chair.
Thank you. I propose the question that the new clause 13B be now read a second time. I now put the question that the new clause 13B be now read a second time. Will as many as are other opinion say aye? Will as many other opinion or contrary opinion say nay? The ayes have it. I now propose the question that the new clause 13B be part of the bill. I put the question that the new clause 13B be part of the bill. Will as many other opinion say aye? Will as many other opinion say nay? Members, may I request that we be attentive so that we vote audibly.
Clause 2.
I propose the question that clause 2 part of the bill. Chair, your amendment to clause 2.
Yes, thank you, Honorable Chair. I beg to move that clause 2 of the bill be amended. In A, in the definition of carbon market by inserting the word products immediately after the word initiatives. B, in the definition of carbon offsets by inserting the words with equivalent number of emissions immediately after the word compensate. And C, by deleting the definition of carbon project and substituting thereof with the following new definition. Carbon project means interventions including programs, projects, and products designed to remove, reduce, sequester, or avoid carbon emissions. And D, in the definition of stakeholders by inserting the new word community immediately after the word business. Honorable Chair, this is just to give strength or more further clarification to the respective clause. Thank you.
Thank you. Honourable members, I propose the question that clause 2 be amended as proposed by the Honourable Gikaria. I now put the question that clause 2 be amended as proposed by the Honourable Gikaria. Will as many of that opinion say aye? Will as many of the opinion say nay? The ayes have it. I now put the question that clause 2 as amended is part of the bill. Will as many of that opinion say aye? Will as many of the opinion say nay? The ayes have it.
Title.
I now propose the question that the title be the title of the bill. I put the question that the title be the title of the bill. Will one of that opinion say aye? Will as one of that opinion say nay? The ayes have it.
Clause 1.
I now propose a question that clause 1 be part of the bill. I put the question that clause 1 be part of the bill. Will as many as of that opinion say aye? Will as many contrary opinion say nay? The ayes have it. Before I finish, these members allow me to welcome students from Njenga Karume Secondary School, Molo, students from Molo Secondary School itself, in Molo again, and students from Changuan Secondary School, Molo, all of three of them from Nakuru County. They are welcome to follow the proceedings of the House this morning. Members, we welcome our pupils by stamping our feet. It's always the tradition. I also wish to recognize the Speakers Gallery, the students from Koiwa Central Secondary School, from Konoin constituency in Bomet County. They are welcome to follow our proceedings this morning. I've started with these ones. So what do we do?
But I'm just willing to hold. You guys will
May I now call the mover of this bill to report? Majority Leader is the mover of this. You're moving for reporting, Majority Leader.
Honorable Chairperson, I beg to move that the committee do report to the House its consideration of the Climate Change Amendment Bill, National Assembly Bill number 42 of 2023, and its approval thereof with amendments.
Honorable members, I now put the question, which is that the committee do report to the House its consideration of the Climate Change Amendment Bill, National Assembly Bill number 42 of 2023, and its approval thereof with amendments. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it. Members, we will not move to reporting, we will move to the next bill, which is the anti-money laundering bill. Where is it? You have a point of order or want to?
No.
The Honorable Murugara, I wish to request you to be very attentive on this so that we bite it fast. Give it a minute.
My card.
Give it a minute.
All right. Thank you. You know where I am.
I don't see him in the house. Is Honorable Shakil in the house? Okay. So, honourable members, as you realize, the anti-money laundering bill is called the Anti-Money Laundering and Combating of Terrorism Financing Laws Amendment Bill number 35 of 2023 has provisions that capture or that cut across so many other acts of parliament, what you'd call omnibus. And therefore, I would request members who have amendments on this to be very attentive so that we're able to move fast. So we'll start with Honorable Shakil Shabir if he's in the House.
Let me read the act.
Order. Order.
Provisions relating to extradition, contiguous and foreign countries act, cap 76.
Honorable Shakil, if he's not there, I propose the question that the provision relating to section 7A immediately after section 7 of the bill be amended, be part of the bill. Honorable Shakil is not there, so we drop the amendments relating to Honorable Shakil. I then go on to propose the question of the provision relating to section 10A be part of the bill. Honorable Murugara.
Thank you, Honorable Chair. I propose that Section 10A of the Extradition, Contiguous and the Foreign Countries Act, Cap 76, be amended as per the order paper. The justification is that we have to harmonize the expeditious disposal of the matter and also protect the human rights of a fugitive who has to be extradited. Thank you, Honorable Chair.
Thank you. I propose the question that provision relating to section 10A be amended as proposed. I now put the question that the provision relating to section 10A be amended as proposed. Honorable Murugara. Will, as many of our opinion say aye? Aye. Will as many of the contrary opinion say nay? I now put the question that provision relating to section 10A as amended be part of the bill. As many of the opinion say aye? Aye. Will as many of the contrary opinion say nay? The ayes have it.
Provisions relating to extradition, Commonwealth Countries Act, cap 77.
I propose the question that provisions relating to subsection 7, subsection be part of the bill. Honorable Shakil, on the House, or is dropped. I go ahead to propose the question that provision relating to section 13A be part of the bill. Honorable Murugara.
Thank you very much, Honorable Chair. Chair, the proposal is similar to what we have done for the extradition, contiguous foreign countries. It's purely to propose that section 13A be part of the, 13A be amended as per the order paper. And the rationale is the same. As we have expeditious disposal of persons to be extradited, we have also to ensure that their human rights are protected. Human, legal rights, and all rights. Thank you.
I propose the question that the provisions of relation section 13A be part of the bill, be amended as proposed by the Honorable Murugara. Any takers on this? I now put the question. Yes, Honorable.
Mr. Chairman, the amendment is proper, especially because these people, these fugitives, many times do not have competent legal representation. But could I ask the Chair to include in his amendments in this area of consent, where he's saying that the consent obtained under this section shall blah blah. Could you, if you don't mind, it will only reinforce what you have there, that it should be in writing. A consent should be in writing so that we avoid situations in which these consents are derived at orally by way of extrajudicial means, including torture and so on. If you could further amend, which just reinforces the amendment that you are having, that the consent will be in writing, I hope we will be in a better footing.
The Honorable Murugara, just take your seat a minute. The Honorable Justice Kemei.
Chair, thank you, Chair. I wish to support the amendment by the Honorable Murugara, Chair, that much as we recognize that fugitives may have committed a crime here and there, we must honor their constitutional rights as while we are also expediting the issue of extradition. So, Chair, I do support. Thank you.
Thank you. Honorable Murugara.
Thank you. I've heard a proposal by Honorable TJ, but I wish to confirm that this consent is actually in writing. Essentially, you can see it is actually being witnessed. It cannot be witnessed in an oral manner. But however, there may come a time when the consent has to be taken in court, and therefore it will have to be through oral proceedings in court. Again, possibly the court will be the witness. I think we leave it as it is. There is latitude for both of them. Thank you.
Thank you. And members, this is for all members. Order. It used to be, and I will encourage it to be always, that where we have, you want to request a member to amend the amendment, just talk to them before, not on the floor, just talk to them before so that we have some agreement, so that when you're speaking, the person being requested also has knowledge. It makes a lot of sense and makes work very easy. Members, I go on to put the question. The provisions relating to section 13A be amended as proposed by Honorable Murugara. Will, as men of that opinion, say aye? Aye. Will, as men of that opinion, say nay? The ayes have it. We had a simple amendment on section 13A by Honorable Shakil, but it's not in, so it's dropped. I go ahead to put the question. The provisions relating to section 13A as amended be part of the bill. Will as men of that opinion say aye? Aye. Will as men of that opinion say nay? The ayes have it.
Provisions relating to the State Corporations Act, Cap 446.
I propose the question that provisions relating to section provisions relating to State Corporations Act, Cap 446, be part of the bill. I now put the question that provisions relating to section go ahead.
Mr. Chair, you know, we are dealing with what you're describing as omnibus omnibus legislation. So permit us, the report is fairly big. The act is also fairly big. If you could, if we want to be together, please point to us the areas of the bill which we are handling at every given period of time, the page if possible, and because we are looking at the order paper at the same time we are looking at the committee's reports, and you know that there are several committees that have handled this. So just so that we are being with you, please just guide us in specific pages that we are handling where we come to amendments.
No, that's so much in order, Senior. We are now dealing with page 1067 of the bill. Page 1067. I don't know if the order paper, what number it is in the order paper. The order paper is page 936 in the bill, page 1067. So in the order paper, because there's no amendments, you won't find it in the order paper, but on the text of the bill, page 1067. Honorable members, I am now putting the question that the provision relating to the State Corporations Act, Cap 446, be part of the bill. Will as many of that opinion say aye? Will as many of that opinion say nay? The ayes have it.
Provisions relating to the Capital Markets Act, Cap 485A.
I propose the question that provisions relating to the Capital Markets Act, Cap 45, 485A be part of the bill. This is, members, on again page 1067 of the bill. I propose a question. The provisions relating to section 12 of the Capital Markets Act 485 be part of the bill. Mover, Honorable Kuria Kimani.
Thank you, Honorable Chair. I beg to move that the Capital Markets Act be amended as per the order paper.
What is the import of the amendment?
So this, Honorable Chair, is to align with the Bill of Rights so that we ensure that even the people affected by the Act has powers to, their rights are not infringed as per the Bill of Rights.
Thank you. Any takers on that? And now, I propose the question, the provision relating to section 12 of the Capital Markets Act 485A be amended as proposed. I put the question that the provision relating to section 12 of the Capital Markets Act Amendment Cap 486 be amended as proposed by the Honorable Kimani Kuria. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it. I now put the question that the provisions relating to section 12 of the Capital Markets Act Cap 485 as amended be part of the bill. Will as many of the opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
New section 12A and B.
I propose the question that the provision relating to new sections 12A and B of the Capital Markets Act Cap 485A be part of the bill. Honorable Kuria.
Thank you, Honorable Chair. I move that the amendment be done as per the order paper. So this is cutting across several sectors, several acts on the Insurance Act, and mainly it is what I said in aligning this with Article 24 of the Constitution on the limitation of.
Honorable Kuria, you're still at the Capital Markets.
Okay.
You're remembering.
Oh, okay, yes. I beg to move, Honorable Chair, I beg to move that this amendment be as per the order paper and it's the explanation I have given above in terms of limitation of rights. I beg to move, Honorable Chair.
Thank you. I propose a question that the provisions relating to sections new clauses 12A and 12B be amended as proposed. I now put the question that the provisions relating to sections new clauses 12A and B be amended as proposed. Will as many as of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it. I now put the question that the provision relating to new clauses 12A and B as amended be part of the bill. Will as many of that opinion say? Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
New section 35A and 35B.
I propose the question that provision relating to new sections 35A and 35B be part of the bill. Mover.
Honorable Chair, I beg to move that section 34A and 35B, these amendments to the Capital Markets Act. That 5A be and that 5B be amended as per the order paper.
Just
again, same reason I had given above. This is to align this with the Constitution on the on justification on human rights, so that we make sure that the rights of these people are not infringed. So this is just in line with the Constitution in terms of infringement of human rights.
Thank you. I propose, members, the question that the provisions relating to new clauses 35A and 35B of the Capital Markets Act Cap 485A be amended as proposed. Yes, Honorable TJ. It's spent. Give Honorable Kajwang the mic. Just give him the next. The one next. Yeah? Which one?
Mr. Chair, I know you said that with good wisdom that we should approach the chairs of the committees to discuss these issues. But as you know, we have just explained that it is coming from several committees, and many of them we are interacting with them. You can see the speed with which this legislation is going. So just indulge us in a few things. We just want to make good legislation in particular areas. And I am just looking at 35B, and I agree this is a beautiful way of entrenching people's fundamental rights and limiting them by statute. I think that is what the courts have ruled before. But Chair, if you consider, the committee chair, if you consider 35B in subsection 2, where a person is suspected or accused of any offense under this act, the person's home or property may be searched. If you just do a further amendment, a small one, and say the person's home or property may, with a warrant, be searched. Just add the word warrant, with a warrant, be searched. Now, that would make sure that these people who are looking for fugitives or harassing people in their homes and so on would have to obtain a warrant before a magistrate or before a judge, and therefore there would be some type of proceedings in which these people are able to protect their rights. So just the words, the person's home or property may, with a warrant, be searched. Thank you, Chair. I know there is already in the law, including 35A is in the law, it is in the Constitution. This is why we are repeating it. The entire 35A that persons will enjoy fundamental freedoms and rights, that is in the law, it's in the Constitution. So we are just being very clear, and we are being particular, especially you followed what happened to Miguna. Yes, we abandoned him because he abandoned us before we abandoned, but I don't want to waste Chair's time. Miguna was visited by people who, without warrant, searched his home, and searching a home cannot be tasteful if you want. So with a warrant, that now brings those proceedings before a magistrate or the court. Thank you, Mr. Chair.
Now, I want to hear from the Honorable Kuria. I'll come to you, the Honorable Kela.
I think, Honorable Chair, I want to agree with my senior, Honorable TJ Kajwang, that when you make these laws, you should make them for prosperity. And therefore, if adding the word warrant assures that the rights of these people will be better taken care of, it's an amendment that we are willing to accommodate. So we agree that we adopt Honorable TJ Kajwang's amendment and add that the person's home or property may be searched with a warrant. With that, I move on, Honorable Chair.
Thank you so much, and I really appreciate Chairperson. Are we dealing with the same issue? Okay, the Honorable Okello.
Chair, thank you very much, and I want to thank the Chair of Finance for accepting the change, because again, we have seen areas where certain sections of the law are susceptible to abuse by the powers that be, and we have lately seen how, without proper definition, government can interfere, so to speak, in the name of political vendetta. So if a warrant will be coming from a court of law a competent court of law, Honorable Speaker, then that is the line to take, and I support the amendment.
Thank you, the Honorable. 1 minute, the Honorable Martins of Niwa.
Chair, this is very important. Also, could this be applied on 2C? Chair, the financial information of people, families, and private affairs is very, very important. Could that be applied as well? Because if just left open, these are very important documents families do have and individuals. Thank you, Chair.
Thank you. Members, Honorable Kuria.
You know, I would nudge my honorable colleagues, since we have accommodated the issue of needing to have a warrant of arrest for search and property, we don't necessarily have to add that to information, because honorable Chair, all these laws must be within the confines of law. So we would even expect that sharing of this information would be within the Data Protection Act. And therefore, us passing this law does not give any powers to break any other law of the land. And with that, I don't think we really need to add that. So I think the amendment by TJ Kajwang suffices in terms of enshrining the rights of those people.
Perfect. I think I like the spirit, bipartisan spirit is the best. I now go ahead to put the question that the provisions relating to sections 35A and 35B of the Capital Markets Act, Cap 485A, be amended as proposed. Will, as many other opinions, say aye? Will, as one opinion, say nay? The ayes have it. I now put the question, members, that the provisions relating to section 35A and 35B of the Capital Markets Bill Act as amended part of the bill. Will, as one of that opinion, say aye? Aye. Will, as one of the opinion, say nay? The ayes have it.
Provisions relating to the Insurance Act, Cap 487.
I propose the question that provisions relating to section 128 of the Insurance Act be part of the bill. Mover.
Honorable Chair, I beg to move that the Insurance Act be amended as per the order paper. So essentially, this amendment, Honorable Chair, is aligning that with the existing tax laws, where we are required to keep records for any business for 7 years. So we are deleting the word 5 and replacing that with 7, so that it is in line with our tax law that requires any company or any business to hold their records for a period of 7 years.
Members, I propose the question that provisions relating to section 128 of the Insurance Act be amended as proposed. Any takers? I now put the question that the provisions relating to section 28 of the Insurance Act be amended as proposed. Will, as one of that opinion, say aye? Aye. Will, as one of that opinion, say nay? The ayes have it. I now put the question that the provisions relating to section 128 of the Insurance Act as amended be part of the bill. Will, as one of that opinion, say aye? Will, as one of the opinion, say nay? The ayes have it.
New sections 196B, 196D, 196E, and 196E.
I propose the question that the provision relating to sections, new sections 196B, 196C, and 196D be part of the bill. Mover.
Honorable Chair, I beg to move that the Insurance Act be amended as per the order paper, amending 196C, D, and E. And Honorable Chair, this is again what I explained above in ensuring that the rights, that this is in line with Article 24 of our Constitution on Bill of Rights.
Thank you. I propose the question that the provisions relating to new sections 196B, D, and E be amended as proposed. I now put the question that new provisions related to new clauses 96B, C, D, and E be amended as proposed. The Honorable Kajon.
Yes, Mr. Chairman, these two, just like what we have come through in 196E, where a person is suspected or accused of an offense under this act, the person's home or property may, with a warrant, be searched. You know, I don't begrudge the chair. You know, he had moved C, D, E together, and so he could have not been particular to the amendment. So in E, it just bespeaks what we have just come from in the other one. So if the chair could indulge me, he could put a further amendment and we can vote it together.
The Honorable Chair.
Yeah, again, Honorable Chair, we heed to Honorable TJ's amendment as we decided on the other clause before. So I beg to move that that clause be amended by inserting the word with a warrant of arrest as proposed by Honorable TJ Kajwang. And with that, I beg to move.
Great. I now put the question that the provisions relating to new clauses 19C, D, and E be amended as proposed. Will, as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it. I now put the question that the provision relating to a new sections, new clauses 19C, D, and E be as amended be part of the bill. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Section 205.
I propose the question that the provisions relating to sections 205 of the Central Bank, which act? Of the Insurance Act be part of the bill. Move on.
Honorable Chair, I beg to move that the Insurance Act be amended as per the order paper, and this is the same reason as above, to make sure it's in line with Article 24 of our Constitution on human rights.
Thank you. I propose the question that the provisions relating to Section 205 of the Insurance Act be amended as proposed. I put the question that the provisions relating to Section 205 of the Insurance Act be amended as proposed. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it. I now put the question that the provisions relating to Section 205 of the Insurance Act as amended be part of the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Provisions relating to the Banking Act, Cap 488.
I propose the question that provision relating to Section 2 of the Banking Act be part of the bill. Move on.
Yep. Honorable Chair, I beg to move that the amendment onto the Banking Act be as per the order paper. And Honorable Chair, the proposed definition is seeking to define the terms as contained in the bill, and this enables the vetting of beneficiary owners who are significant shareholders in money remittance providers. This requires that CBK, money remittance providers, and digital credit providers be identified. With that, I beg to move, Honorable Chair.
Thank you. And I propose a question that the provisions relating to Section 2 of the Banking Act be amended as proposed. Any takers? I put the question that the provisions relating to Section 2 of the Banking Act be amended as proposed. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it. I now put the question that the provisions relating to Section 2 of the Banking Act as amended be part of the bill. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Section 33E1.
I propose the question that the provision relating to Section 33E1 of the Banking Act be part of the bill. Move on.
So, Honorable Chair, I beg to move that the amendment be as per the order paper, and this is in line with the Article 24 on human rights.
Members, I propose the question that the provision relating to Section 33E1 of the Banking Act be amended as proposed. I now put the question that the provisions relating to Section 33E1 be amended as proposed. Will as many of our opinion say aye? Will as many of the court of opinion say nay? The ayes have it. I now put the question that the provisions relating to section 33E1 of the Banking Act as amended is part of the bill. Will as many as of that opinion say aye? Will as many as of the court of opinion say nay? The ayes have it.
New section 54A. 54A and B.
I propose the question that the provisions relating to new clauses 54A and 54B be part of the bill. Mover?
Honorable Chair, I beg to move that 54A and 54B be part of the bill. And Honorable Chair, if I am correct, this would again require that we amend the words, the person's home or property may be searched to include warrant, as proposed by Honorable T.J. Kajwang. So I beg to move with amendment that we add the words with search with warrant as earlier proposed. With that, I beg to move, Honorable Chair.
Thank you. Members, I propose the question that the provisions relating to sections new sections 54A and 54B be amended as proposed by the Honorable Courier. I put the question. The provision. Yes, Honorable Kajwang.
Yeah, just for records, the chair is referring you to 54B, subsection 2A.
Yes.
The words
yes.
with warrant.
I'm with you totally. Thank you. I now put the question that the provisions relating to new sections 54A and 54B of the Banking Act be amended as proposed. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it. I now put the question that the provisions relating to the new clauses 54A and 54B as amended be part of the bill. Will as many of our opinion say aye? Will as many of the contrary opinion say nay? The ayes have it. Members, before we proceed, I just wish to recognize the presence of Changwan Secondary School from Molo County, from Molo constituency in Nakuru County, and pupils from Dalani Primary School, Yatta constituency, Machakos County, in the public gallery. They are welcome to follow the proceedings of the House this afternoon.
Provisions relating to the Central Bank of Kenya Act, Cap 491.
I propose the question that provisions relating to Section 4A of the Central Bank of Kenya Act Cap 491 be part of the bill. Mover.
Honorable Chair, maybe before I move, if I could indulge you, I would like to welcome the students from Molo constituency who are welcome to observe our proceedings today. Today we have a total of 650 students from different schools across the constituency. So we make sure we give them this time to come and observe our proceedings. And of course, they're coming to Nairobi is also a big thing. I could write a book about my first trip to Nairobi, but that's a story for another day.
They are most welcome.
Thank you very much, Honorable Chair. So, Honorable Speaker, Honorable Chair, I would like to move that the Central Bank Act be amended as per the order paper, and I had given this explanation before, that this the proposed definition seek to define the terms as contained in the bill, and this will enable the vetting of the beneficial owners who are significant shareholders in money remittance providers, and this will also further require Central Bank of Kenya, all money remittance providers, digital credit providers, to identify the persons who are exercising ultimate control in a money remittance provider or a digital credit provider. With that, I beg to move, Honorable Chair.
Thank you. I propose the question that the provisions relating to Section 4A of the Central Bank of Kenya, Cap 491, be amended as proposed. Yes, Honorable.
Mr. Chair, did we deal with Microfinance Act? My order paper seems to suggest Microfinance Act before the Central Bank Act. That's why I was lost and I was trying to get where I am.
No, you're right. We are coming to microfinance shortly after this.
Okay, thank you.
Just after this, shortly. Members, allow me to go back on the Central Bank of Kenya Act. And what we are proposing to do is to, in that case, amend the definition section. So I would request the chairperson to come back.
Oh, yes. So, Honorable Chair, yes.
So that just take your seat. So that I'll be proposing the question that provisions relating to Section 2 of the Central Bank of Kenya Act be amended, be part of the bill. Then you now can move. Just move the way you moved.
So I repeat what I did.
Yeah, same thing.
So, Honorable Chair, I beg to move that the Central Bank Act be amended as per the order paper.
Yes.
And I don't think, Honorable Chair, I need to
No,
belabor
no,
on
you
the
don't have
justification of it. So I beg to move that the Central Bank Act be amended as per the order paper.
Thank you. I propose the question, the provisions relating to Section 2 of the Central Bank of Kenya Act be amended as proposed. I now put the question that the provision relating to Section 2 be amended as proposed by Honorable Kuria. Will as many as of that opinion say aye? Aye. Will as many of the counter opinion say nay? The ayes have it. I now put the question that provision relating to Section 2 of the Central Bank of Kenya Act as amended be part of the bill. Will as many of that opinion say aye? Aye. Will as many of the counter opinion say nay? The ayes have it. Members, I wish now to propose that the provisions relating to sections, new sections 51A, new section 51A, 51B, 51C, and 51D be part of the bill. Mover.
Honorable Chair, I beg to move that Section 51A, B, and
C and D,
C and D be amended as per the order paper.
Justification? Justification on this?
Honorable Chair, this new provision of 51 A, B, and D is seeking to give powers on anti-money laundering, combating and enhancing terrorism and counterfeit purification in terms of their financial matters, Honorable Chair.
Thank you. I now propose the question that the provisions relating to sections 51A, B, C, and D immediately after section 51 be amended as proposed by Honorable Kuria. Any takers on this? I put the question. You want to say something, Honorable Kajwang? Go ahead.
I'm just reminding the chair of page. I don't know what page of this is the other paper, but
it's 51D. You want to put it 51D, right?
With the warrant on subsection 2A.
The Honorable Chair, 51D, if you want to do the same honors again.
Yes, again, Honorable Chair, in the spirit of making sure that we protect the rights of every Kenyan, I propose that we add the new words with a warrant as proposed by my good friend Honorable TJ Kajwang, and as I had proposed in the earlier amendment, so that no search can be done to anyone's property or home without a warrant of arrest, without a search warrant being issued.
Thank you. Honorable Nyamai.
Thank you very much, Chair. I would like to support the chairman and also agree with the Honorable TJ Kajwang. Looking at what is stated in A, B, C, and D is quite heavy, so it is important that it is done with a warrant. Thank you, Chairman.
Thank you. I now put the question that the provisions relating to new sections 51A, 51B, 51C, and D be amended as proposed. Will as many as of that opinion say aye? Will as many as of the counter opinion say nay? The ayes have it. I now put the question that the provisions relating to new sections 51A, B, C, and D of the Central Bank of Kenya Act as amended be part of the bill. Will as many of that opinion say aye? Aye. Will as many of the counter opinion say nay? The ayes have it.
Provisions relating to the Microfinance New Act 2006.
Thank you. I propose the question that the provisions relating to Section 2 of the Microfinance Act 06 be part of the bill. Honorable Kuria.
So, Honorable Chair, I beg to move that the Microfinance Act be amended as per the order paper. Again, this Honorable Chair is making sure that this is in line with Article 24 of our Constitution in terms of infringement of human rights. But again, the same spirit of the other amendments that you've done before, I would propose that 48B.
We are not there yet. We are just at 2 yet.
Oh, okay, fine. So I beg to move that the Microfinance Act be amended as per the order paper.
And members, this has been explained, just that the microfinance deals with the microfinance institutions, and the banking act deals with the banks. But in terms of the explanation about the beneficial owner and the significant shareholder are the same totally. So I would therefore propose the question that the provisions relating to Section 2 of the Microfinance Act of 06 be amended as proposed. Any takers? I now put the question that the provisions relating to Section 2 of the Microfinance Act of 06 be amended as proposed. Will as many as of that opinion say aye? Aye. Will as many as of contrary opinion say nay? The ayes have it. I now put the question, the provision relating to Section 2 of the Microfinance Act as amended be part of the bill. Will as many as of that opinion say aye? Aye. Will as many as of contrary opinion say nay? The ayes have it. Members, I propose the question that provisions relating to Section 36C of the Microfinance Act 06 be part of the bill. Mover.
Honorable Chair, I propose that still the Microfinance Act, right? Yes, the Microfinance Act be amended as per the order paper. Oh yes, that's where we add. So, Honorable Chair, if I'll indulge you, I propose a further amendment to the Microfinance Act on 47B 2A, where we're saying the person's home or property may be searched, to add the word that the person's home or property may be searched with a warrant.
The Honorable Kuria, you realize that 36C has two parts of it. So the first part talks about deleting the word 20. So would you want to explain that?
Okay, fine. So let me start. Honorable Chair, I beg to move that the Microfinance Act be amended as per the order paper, and this is deleting the word 20 that are appearing on subsection 2A, and I'm starting that therefore with the word 5. That would be the first part, and then part.
What is the justification for that?
Give me a second, Honorable Chair.
Why can't you do them together?
Because this one is only giving directions where the insertion is coming.
Okay. And Chair, after that, you allow us to put a question on that one first before you go to the next.
So Honorable Chair, thank you for your indulgence. This amendment is reducing the penalty from the penalty of 20 million to making it 5 million. And this, Honorable Chair, is to make the penalties less punitive in the event that someone finds that they may not have done as per the act. So the deletion of 20 and replacing thereof with 5 is to make the penalties less punitive by reducing the penalty from 20 million shillings to 5 million shillings.
Members, I propose the question that provision relating to Section 36C be amended as proposed. Go ahead, Honorable Shakil.
Speaker, sir, as much as I appreciate the attempt to try and reduce the burden of non-compliance, I think there is, the reason 20 was put there was that it will be a warning, sort of of action that if it's a 20 million, then somebody will take it more seriously. But if you now reduce it back to the proposed 5 million, others are going to take this with a pinch of salt. I feel that this, we have to come back into a society where we are able to rule and accept and work within rules. So I do oppose the reduction from 20 to 5.
This can go either way. Members, I put the question.
I want to support the Chair of Finance, Honorable Chair, by reducing the fine from the penalty from 20 to 5. The reason being, Honorable Chair, it's not that when you are fined more, you'll have to comply. Compliance, Honorable Chair, does not originate from the amount that is fined, but how flexible you are to comply with the law. Therefore, I wish to support that, Honorable Speaker.
I want this to go either way, and therefore put the question. You want to? I want to put the question on this matter, that the provisions relating to section 36C be amended as proposed by the chair. Will as many of that opinion say aye? Will as many of that opinion say nay? Nay. The ayes have it. Go ahead. I go ahead now to propose the question that the provisions relating to sections, to new sections 47A and 47B of the Microfinance Act of 06 be part of the bill. Mover?
So, Honorable Chair, I beg to move that Section 47A and Section 48B be amended as per the order paper. And again, this is an amendment to the Microfinance Act. And this one, Honorable Chair, I beg to move a further amendment that 47B be further amended, Section 2A, by adding the words warrant, so that 2A reads, the person's home or property may be searched with a warrant as proposed in the other clauses. With that, I beg to move, Honorable Chair.
I propose a question that the provision relating to sections, new sections 47A and 47B be amended as proposed by the Honorable Courier. I put the question that the provisions relating to new sections 47A and 47B of the Microfinance Act of 06 be amended as proposed. Will as many of our opinions say aye? Will as many of our opinions say nay? The ayes have it. I now put the question that the provisions relating to sections, new sections 47A and 47B of the Microfinance Act of 06 be as amended be part of the bill. Will as many of our opinions say aye? Will as many of the counter opinions say nay? The ayes have it.
Provisions relating to the Anti-Corruption and Economic Crimes Act, number 3 of 2003.
Members, I wish to propose the question that provisions relating to various sections of the Anti-Corruption and Economic Crimes Act, number 3 of 03, be part of the bill. I put the question that the provisions relating to a number of sections in Anti-Corruption and Economic Crimes Act, number 3 of 03, be part of the bill. Will as many of our opinions say aye? Will as many of the counter opinions say nay? The ayes have it.
Provisions relating to the Proceeds of Crime and Anti-Money Laundering Act of 2009, number 9 of 2009.
Honorable members, this notify you that the Act, Proceeds of Crime and Anti-Money Laundering Act of 09 has a number of amendments, and I will start by proposing the question that the provision relating to Section 2 of the Proceeds of Crime and Anti-Money Laundering Act be part of the bill. Mover?
Thank you. Thank you, Mr. Chairman. I move that Section 2 of the Proceeds of Crime and Anti-Money Laundering Act be amended as per the order paper. This is purely to have a definition of self-regulatory body, meaning the Law Society of Kenya, as proposed by the Law Society itself.
Honorable members, I propose the question that the provisions relating to Section 2 of the Proceeds of Crime and Anti-Money Laundering Act 09 be amended as proposed. Yes, Honorable Kajun.
I think this is where, Mr. Chair, just remind us so that we move together where we are on this this amendment concerning.
This is page 936 of the order paper.
Yes,
936 of the order paper.
Okay, things have moved from digital, from paper to digital, making some of us very unhappy. But Chair, generally, I want to support the Chair that to the extent that the Law Society has been made a self-regulatory entity in this bill, serves a lot of purposes. You know, eases a lot of problems that we have had before. I would just be waiting at the particular amendment on the self-regulatory body to make sure that the Law Society also has powers to make regulations that would self-regulate it effectively as has been proposed. The chair of JLAC is listening. I have supported, but I'm waiting for this specific amendment that bringing in Law Society as a self-regulating body with powers to make regulations. Mr. Chair, you know you are in delegated legislation, Chair of JLAC. Yes, Chair of JLAC, you served in Committee on Delegated Legislation. And you know that if the section does not expressly provide for powers to make regulations under it, it would be it would not be useful even if they were to regulate. And so I'm waiting for that provision in which then you expressly say then that the Law Society has the powers to make regulations for under that section for self-regulation. Thank you, Madam Chair.
Honorable Murugara.
That is an observation that may come in when we go to amend the Law Society of Kenya Act. It's not relevant to this particular proposal or what I have moved. So what I have moved remains what I have moved, which is an amendment to Section 2 to insert this definition of a self-regulatory body to mean the Law Society of Kenya.
Thank you. Yes, the Honorable Millie.
Thank you, Chair. Chair, I don't know if the Honorable Chair of the Justice Committee was actually listening to Honorable Kajwang. Honorable Kajwang was just throwing a caution that when you actually come to the part of self-regulating by the Law Society later, that you need to actually put regulations. And as a lawyer, I think that is important, not now. So perhaps if you, I notice you are a little distracted by the leader of majority you are consulting. So maybe it would be nice if you listened to that. It's coming later, not now.
Honorable Ugara, these honorable members are with you on your proposal. They are not opposing your proposal. They're just giving you a proposal that when the right time comes,
give me this. They're just being preemptive. Let's cross the bridge when we come there. The Law Society has a section on making regulations in the body of it. So every section is
order. I think we are moving very well with the bipartisan spirit from the morning. I would encourage the same spirit as we go on with this particular. Let's go on, members. I now put the question that the provision relating to Section 2 of the Proceeds of Crime and Anti-Money Act of 09 be amended as proposed. Will as many as of that opinion say aye? Will as many of that opinion say nay? The ayes have it. I now put the question that the provisions relating to Section 2 of the Proceeds of Crime and Anti-Money Act of 09 as amended part of the bill. As many of that opinion say aye? Will as many of that opinion say nay? The ayes have Section
8.
I propose the question that the provision relating to Section 8 of the Proceeds of a Crime and Anti-Money Act be part of the bill. Mover.
Honorable Chair, I move that the new subsection 4 be inserted as proposed on the order paper. The justification is to ensure that advocates, notaries, public, and other independent legal professions are not guilty of the offense of tipping off if they actually do what this section provides. Tipping off is an offense under various laws in the country.
Thank you. I propose a question that provisions relating to Section 8 of the Proceeds of Crime and Anti-Money Act be amended as proposed. I put the question that the provisions relating to Section 8 of the Proceeds of Crime and Anti-Money Act of 09 be amended as proposed. Will as many other opinion say aye? Aye. Will as many contrary opinion say nay? The ayes have it. I now put the question that the provisions relating to Section 8 of the Proceeds of Crime and Anti-Money Act of 09 be as amended be part of the bill. Will as many other opinion say aye? Aye. Will as many contrary opinion say nay? The ayes have it. I propose the question, members, that the provisions relating to sections 36(1), 36(2), 36(a)(2), 36(a), 36(a)(4), 36(a)(5), 36(a)(5)(c), 36(5)(d), 36(a)(6), 36(a)(7) be part of the bill. Mover.
Thank you, Mr. Chairman. I propose that section 36, right from 1 to 36(a)(7 be amended as proposed on the order paper. This is purely routine to ensure that the self-regulatory body is now captured in the Act, and this refers to the Law Society of Kenya.
Here I propose the question that the provisions relating to sections 36(1), 36(2), 36(a)(2), 36(a), 36(a)(4), 36(a)(5), 36(a)(5)(d), 36(a)(6), 36(a)(7 be amended as proposed. Any checkers? I now put the question that the provisions relating to sections 36(1), 36(2), 36(a)(2), 36(a), 36(a)(4), 36(a)(5)(c), 36(a)(5)(d), 36(a)(6), and 36(a)(7 be amended as proposed. Will as many as other opinions say aye? Aye. Will as many other opinions say nay? The ayes have it. Members, I now put the question that the provisions relating to sections 36(1), 36(2), 36(a)(2), 36(a), 36(a)(4), 36(a)(5)(c), 36(a)(5)(d), 36(a)(6), 36(a)(7 as amended be part of the bill. Will as many other opinions say aye? Aye. Will as many other opinions say nay? The ayes have it. All members, I propose the question that provisions relating to section 44 of the Proceeds of Crime and Anti-Money Laundering Act of 09 be part of the bill. Mover.
Thank you, Mr. Chairman. I propose that the new section 30, subsection 3A, 3B, and 3C be amendments as shown on the order paper.
Chairperson, just a minute. Remember that section 44 has two. You are making a proviso before you go to the new subsections. So will you move the proviso?
Yes. Thank you very much. The first is section 44. Proviso is be adopted as shown on the order paper, and this is purely to ensure that lawyers, notaries, and other independent legal professions may submit their reports to the Law Society of Kenya, which now becomes a self-regulating body.
Members, I propose the question of the provisions relating to section 44, sub 3 be amended as proposed. And I put the question that the provisions relating to section 44, provision 3 be amended as proposed. Will as many other opinions say aye? Aye. Will as many other opinions say nay? The ayes have it. I propose the question I now put the question that the provision relating to section 44, provision 3, as amended, be part of the bill. Will as many of our opinion say aye? Aye. Will as many of our opinion say nay? The ayes have it. Members, I now wish to propose the question that the provisions relating to the insertion of new subsection 3A, 3B, and 3C to the Proceeds of Crime and Anti-Money Act of 09 be part of the bill. Mover.
Thank you, Mr. Chairman. I propose that section 44, subsection 3 be amended as shown on the order paper to include the new provisions of subsection 3A, 3B, and 3C, purely to ensure that this aligns with the Law Society of Kenya being a self-regulating body and they want to take up matters of the Act on behalf of the advocates.
Justification?
That's what I've just given, that the essence is to ensure that it is the Law Society of Kenya that will have to take up these matters on behalf of the lawyers, and it is the one to establish appropriate mechanisms to cooperate for exchange of information relating to suspicious transactions and money laundering.
Thank you. Members, I now propose the question that the relating to the new clauses 3A, 3B, and 3C immediately after subsection 3 of Proceeds of Crime and Anti-Money Act of 09 be amended as proposed. Members, I now put the question that the provisions relating to sections of the new clauses 3A, 3B, and 3C immediately after subsection 3 of the Proceeds of Crime and Anti-Money Act of 09 now be amended as proposed. Will as many as of that opinion say aye? Aye. Will as many of the contrary opinion say nay? The ayes have it. I now put the question that the provisions relating to the new section 3A, 3B, and 3C immediately after subsection 3 of the Proceeds of Crime and Money Laundering Act of 09 be amended, as amended, be part of the bill. Will as many as of that opinion say aye? Aye. Will as many of the opinion say nay? The ayes have it. Members, I wish to recognize the following schools from Molo. Molo Secondary School in Molo, Nakuru County. They are in the Speaker's Gallery. And Dalani Primary School, Amiyata constituency in Machakos County. They are welcome to follow our proceedings this afternoon. The Dalani Primary School are seated in the public gallery. They are welcome to follow our proceedings this afternoon. Order, members, we are moving to the next stage of reporting. And I wish to call upon the move of the bill to move for reporting. Honorable Majority Leader.
Honorable Chairperson, I beg to move that the committee do report to the House its consideration of the Anti-Money Laundering and Combating of Terrorism Financing Laws Amendment Bill, National Assembly Bill number 35 of 2023, up to the provisions relating to the Proceeds of Crime and Anti-Money Laundering Act of 2009 and its approval thereof with amendments, and seek leave to sit again.
Any takers? Members, I wish to put the question, which is that the committee do report to the House its consideration of the Anti-Money Laundering and Combating of Terrorism Financing Laws Amendment Bill, National Assembly Bill number 35 of 2023, up to the provisions relating to the Proceeds of Crime and Anti-Money Laundering Act of 09 and its approval thereof with amendments, and seek leave to sit again. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it.